right, good morning, everyone. It is 9:30. We are resuming this water right change petition hearing for the California WaterFix project. I'm Tam Doduck. Joining me shortly and sitting to my right will be Board Chair and Co-Hearing Officer Felicia Marcus. To my far right is Board Member Didi Diadamo. To my left are Andrew Derringer, Connie Mitterhofer, and Hua Sung Jin. We're being assisted today by Mr. Long and Ms. Wu. I see all familiar faces, so I will skip the usual announcement, except the most important one, as always, as Mr. Herrick knows, is to make sure that all your noise-making devices are on silent, vibrate, do not disturb. Everyone is checking. All right. With that, I believe we are now set up to hear from Clifton Court, and they are direct, after which then we will hear from Mr. Worth and Save Our Sandhill Crane, after which then we will hear from Mr. Bernardsky and Dr. Chimakuri. Any housekeeping matter? Ms. Morris.
Yes, Stephanie Morris on behalf of the State Water Contractors. Mr. Emmerich and I spoke about Dr. Paulson, and because the department and no one else has said that they are going to cross-examine Dr. Paulson, we have an agreement to stipulate that she doesn't have to appear to present her testimony, but that it can come into evidence, except for we do have on Monday some objections to scope, so Mr. Emmerich agreed that he would appear on Monday to handle those.
All right. Thank you. I appreciate the coordination, and I'm sure Dr. Paulson appreciates it also.
Thank you.
Any other housekeeping matter? All right. Before we get to Mr. Emmerich, Ms. Womack, and Mr. Moore, are there any objections to Clifton Court's case? Mr. Mizell.
Yes, good morning. Trip Mizell, DWR. I do have a lengthy list of objections for this morning's testimony from Clifton Court LP.
If you could move the microphone a little bit closer, Mr. Mizell.
Sure. This a little better?
Yes.
Thanks. So if we could bring up CCLP 60, please. Okay, and if we could go to page 9, please. Okay, so starting page 9 at line 15, the section that begins flood protection, and running through page 10, line 3, which is the end of that flood protection section. Department objects to this section of testimony and moves to strike it based upon the fact that it is dealing with seepage. In your oral ruling on August 28th, you were relying upon a July 27th ruling in which we all lengthily discussed whether or not seepage of the existing facilities was within the scope of this hearing, and it was determined at that time it was not. Based upon that ruling, we would object to this as being outside the scope of this hearing and move to strike it.
Before you move on, let's hear from Mr. Emmerich or Ms. Womack.
Yes, I wanted to bring out that on page 9, let's see, 19, we refer to no seepage, but it's a report that says the flood safety standards aren't met, and there's desiccation, cracking in animal burrows, and potential piping. This is a that is a DWR report.
Do you have a response to offer to the specific objection that it's outside the scope of
No, I
survey?
believe flood protection is a very important part of this. As they say, the conveyance facilities are considered to be critical lifeline facilities for the state of California. This is DWR 1304, 4-12. At the beginning of that is there, and so we're saying this is important. Your Clifton Court Forebay, which is a part of the SWP, which you'll be using, is riddled, according to them, desiccation, cracking, and animal burrows and potential piping. This has nothing to do with seepage.
All right.
It does.
Hold on. Anything to add, Mr. Emmerich?
No.
Hold on, Mr. Mizell.
Yes.
Ms. Desjardins is standing behind you. I assume she wants to weigh in on this before I give you the chance to respond.
I would just add that to the extent this project is supposed to deal with sea level rise, the level of flood protection of the facilities after the project is completed is relevant to the board's consideration of whether that, what the petitioners say is one of the main goals of the project will be met. Thank you.
I'm sorry, I forgot that there is another reference to it was determined unsafe to have the diver go further, closer to the south wing wall due to it being unstable. This was a report from March 4th, 2017, where the intake structure facility on the South Shore was unstable. These are two very recent, these are from 2017, very recent, March and, anyway, the two very recent times that they have said the Clifton Court Forebay themselves is unstable.
Mr. Mizell, your response before we move on to your next objection.
Yes. The responses we've just heard relate to existing facilities. I'd simply like to point back to the September 10th, 2018 ruling where we dealt with this very issue. The fact that petitioners are no longer proposing project components that might have remedied pre-existing conditions and are not a change from the baseline would mean that it's not an impact caused by this project and therefore beyond the scope.
Your next objection, Mr. Mizell.
Yes, if we could go to page 10, line 5 through line 8. Line 5 through line 8, we would object and move to strike as again beyond the scope. Here it states that there are no new operations in the SEIR and there are no changes. That's the first two sentences of the lines I'm speaking of. This is testimony related to existing conditions and not related to any changes proposed by the California WaterFix. So I'll leave it at that.
Response?
Yes, in the SEIR EIS that we received in June, I looked very carefully at operations, and they said there are no new operations, and therefore there's nothing. It's one little paragraph. Therefore, there's no operations in the SEIR. Therefore, until I got the CER, I could not look at anything to do with a lot of the operations. This is what, we can look that up.
Next objection, Mr. Mizell, unless Mr. Emmerich, you have something to add. All right.
Nothing right now. Thank you.
If we could go down to line 8 through line 21, same page. This is the remainder of that section. We would object as being beyond the scope and move to strike. Again, this is existing conditions dealing with a drain pipe and its functioning or non-functioning. That drain pipe is not a part of the California WaterFix. Those are existing conditions and not a part of the project.
This speaks directly to DWR saying that we will mitigate, we will maintain. This is a 50-year-old structure that's been leaking for a year. I have letters that I put in from a year ago asking for the repair. Now, during my farm season on September 12th, without consulting the landowner,
Ms. Womack,
yes, I'm sorry.
Now is not the point to actually present your case, which is what you're starting to do.
Okay, let me draw back.
I just want a response to his objection, not your testimony at this time.
Well, we believe this shows how our water rights will be taken by the operations of DFD DWR.
Thank you. That was all you needed to say. Mr. Mizell, next objection.
Certainly, if we could go back up to page 2, please. Thank you. So page 2 is within the Statement of Qualifications portion of CCLP 60. This portion of the exhibit contains numerous arguments, and therefore I'm having a difficult time understanding what is testimony and what is statement of qualifications. So what I have attempted to do, and I'll walk you through it in my objections, is only focus on the argument portions, leaving as much as I could to describe the statement of qualifications. But typically, one would not put substantive argument within your statement of qualifications. So this may appear messy, but I'm trying to only seek to strike portions that I believe are not statement of qualifications, but go to actually substantive arguments.
So before you proceed, was there a particular reason, Mr. Emmerich or Ms. Womack,
Absolutely.
for this?
My father's a farmer. He is not, he's had to become, because of actions, he's become a levy expert. He's become a finance expert when you look at all the money
I
spent.
read your,
So this is things that he has become, had to become. He just wanted to be a farmer. To this day, he
all right, all right.
I think it's intended to be sort of like on a CV, where somebody will have particular projects that they've worked on to show that they are qualified for this.
Exactly.
I think that's what they were
Absolutely.
intending to do here.
So with that in mind, Mr. Mizell, you may now walk us through what you believe are the argumentative statements in this section.
Okay, so on page 2, looking at line 3, about halfway across the line, starting with the word caused, and then proceeding through the citation found on line 6, so ending with CCLP 36. We had moved to strike that as argument within the statement of qualifications, but moreover, beyond the scope of this hearing, because it deals with the construction of Clifton Court Forebay, as it states at the end of line 3 there.
Any respond with specific
Yes.
to this section?
Absolutely. This is how we were made whole. We keep hearing we will be made whole or we will be mitigated. This is our experience so far. I think it's very valuable.
And if it's valuable, why is it not in the testimony portion rather than in the SQO
Well, this is my father's qualifications. This is how he came to be this
Ms.
expert.
Womack, I understand. Let's just move on to your next citation, Mr. Mizell.
Very good. On line 7, beginning at the beginning of that line and proceeding to the end of that sentence that ends with CCF. Again, so just line 7, not the entire sentence, but just from when through CCF. We believe that that's argument not appropriate within the statement of qualifications, and we'd move to strike that.
Let's just move through your entire list, Mr.
Could I have
Mizell.
my father speak to that particularly?
Let's just let him get his list out first.
Okay, can we refer back to that perhaps?
Okay.
Thank you.
If we look at line 11, starting with the word because through the end of that sentence. Similarly, we believe this is argument and should be struck. So moving on to the next paragraph, and please do stop me if you want to.
Let's just get them all out then.
Line 14, starting with the word when, about halfway across. And again, this is where it may get messy. So line 15 at the end of the first bracket, we'd move to strike that,
Okay, let's see.
as well as everything after 1980s to the end of the sentence. So in combination, those two sections of that sentence, then proceeding all the way down to the end of the sentence found on line 20. So in other words, from line 14 to the end of the sentence on line 20, we would move to strike with the exception of the words in the 1980s, because I was attempting to complete the characterization of his qualifications without striking the date range. We would argue that this is beyond the scope of the hearing. It deals with a separate project, the Four Pumps project that took place many years ago. It's not relevant argument to the California WaterFix, and at this point does not provide, well, it's argument on the wrong project.
And is that the entirety of the section you would object to as being argumentative?
No, if we proceed to page 3. From line 1 to line 6, that paragraph, we would also move to strike as argumentative and beyond the scope of this project. Again, it deals with the Four Pumps project, which, as you can see on line 2, was a final EIR from 1986. And then in the next paragraph, on line 9, beginning with the bracketed citations through the end of that paragraph. Again, these are issues dealing with existing conditions in and around the Clifton Court forebay that exist today. They're not a part of the California WaterFix. So that's the completion of the argumentative portions of the qualification statement of Mr. Moore. I have more objections, but I'll wait here because they don't relate to the qualifications argument.
All right, now you may respond to that. And again, not to get into the details of your testimony, but to address the assertion by Mr. Mizell that these are arguments, not statement of qualifications.
Every action has a reaction, and in my father's case, it's almost like he's had to go to school to do each of these things. When they didn't put in a cutoff wall, he had to become an expert in how to deal with it. Then when they changed the rules and they started each thing.
I understand. You don't have to go through each one. That doesn't sound like you have any new rationale to provide, except that these are examples of instances where your father, as a farmer, had to become expert in order to respond to what you allege to be these actions or non-actions by DWR.
Precisely. There's one other thing. The EIR, EIS, we're supposed to be protected by EIR, EIS. The EIR of 1986 specifically talks about riprapping the levees of Old River. We were never riprap. These are, I just want to bring to the board's attention through this.
Again, you are going into arguments. We're just focusing right now on the statement of qualifications. I think you've stated the reason why these sentences were included.
Yes.
And we'll move on from there.
Thank you so much.
And if I may just clarify, the objection is not challenging the qualifications of Mr. Moore or his expertise. We're simply looking to distinguish between proper statements of qualification and argument. I'm not sure if that's helpful, but I hope it is.
I just have...
So, I'm sorry, Mr. Mizell, if those statements were in the non-SQO section,
we would still challenge them based upon scope. So as part of my objection in each case, I went through why they were outside the scope.
All right. Let's move on to your next objection.
So my next objection, the next series of objections are about the exhibit list and not about this, the substantive testimony at this point. So the department is going to object. Well, and here's a question for the hearing officers and how you would like to proceed. The remaining objections I have are on exhibits. In some cases, we have held those objections until the exhibits are moved in, or request to be moved into evidence. If you would like, I can stop here and address those at a later time.
Let's do that, because you've given us plenty to think about right now.
Thank you.
All right, we'll go ahead and take a break and consider these objections.
Could I add one more thing? Just about... Okay. was just, yeah, well, they have to decide.
You know what? That's something.
Closing brief, okay. All right. Okay.
We are back, and let me issue some rulings. Mr. Mizell, your first objection with respect to the discussion of seepage being outside the scope is overruled. You are correct that there is no change in the project or facility, but the change that was made in the administrative draft, SEIR, to no longer build on CCLP's land did change the analysis for Ms. Womack and Mr. Moore regarding potential impacts or injury to their property. Therefore, discussion of seepage is within the scope, and your objection is overruled. Your objections with respect to, well, actually, your remaining objections are also overruled because it is testimony responsive to petitioners during Part 2 rebuttal. Petitioners have assured us and CCLP that any impacts from the WaterFix project would be mitigated. However, without concrete descriptions of what those impacts could be and what form the ensuing mitigation might take. That testimony amounts to petitioner asking CCLP and us to trust you without any specific conditions. Therefore, CCLP's testimony alleging historical and recent pattern of DWR's action or interaction is a trust issue that is relevant to the weight we would give to DWR's assurances. And for that purpose, the remainder of your objections are also overruled, recognizing that there is some argumentative statement in the SQO section of CCLP-60, but those do go towards the trust and the history aspect that I just discussed, and you may, of course, conduct cross-examination on those statements that you believe to be argumentative. Ms. Morris.
Thank you. I'm in a way asking for a motion for reconsideration on the latter half of the rulings. The reason being is...
I'm sorry, please clarify, the latter half?
Well, all of the rulings that you overruled on trust as to recent, like for example, some of the evidence related to fixing a drainage pipeline. Those are factual issues that have nothing to do with California WaterFix, and the Department of Water Resources has not been allowed to put on evidence about those interactions. For example, there is a debate about who owns the drainage pipe and based on a settlement, who it was transferred to. And so that's not fair to take one side's factual allegations without allowing the other side the opportunity. And the department never had that opportunity because those issues like the seepage on existing interactions related to other issues where there's other detailed legal and factual claims are not brought forward to you because they aren't within the scope of the California WaterFix project. So it's inherently unfair to say I'm going to allow one side to characterize the interactions but not allow the other side to put on its assertions to counter those based on facts and legal documents.
Response, Mr. Emmerich or Ms. Womack.
Could I go first? Yes. Let's see. First of all, oh my gosh, I just lost it. Oh my goodness. First of all,
Ms. Womack, let's be very focused here.
Yes.
Ms. Morris' request to us for reconsideration is, as I understand it, and Ms. Morris, I'm sure will correct me if I misstate her motion, is that it would be unfair to not allow the department or petitioners in this matter to respond and provide evidence with respect to the issues that Ms. Womack and CCLP has raised to characterize the trust issue from your perspective.
okay, right. There are two main things. First of all, use your water right as a farmer, you need to be able to pump in and pump out the excess, the drainage.
No, that's not addressing
Okay.
her specific rationale.
Well, okay, the second part is she's talking casually about a drainage pipe and whose is it. There is absolutely,
Again, that's not addressing the crux
okay.
of her rationale. Mr. Emmerich, perhaps you can help?
Yes. I think the reason we're actually here is because DWR made changes to the project over the summer, and we now have an opportunity to put testimony in that addresses some of those issues. One of the issues is, like the board said, DWR saying that they're going to mitigate and hold Clifton Court harmless. I think it's perfectly acceptable for us to put in circumstances in which we feel, or CCLP feels, that DWR did not properly follow up, did not mitigate, did not meet what we think is their obligations. If there's an issue where DWR feels they should be able to respond, I don't think I have an objection to allowing them to respond.
One thing with my father here, I would like him to address, though, this whole drainage pipe. For some reason,
All right, we're not
Just
getting,
because
we
he-
are not getting into the specific arguments with respect to the drainage pipe yet.
well, but who owns?
We are
okay,
not
you're gonna do
there
that.
yet.
Okay.
We're still arguing over not, you get to proceed. So,
Oh.
Ms. Womack, chill.
So
Ms. Meserve, I'm sorry, did you want to add something, Mr.
I just
Chairman?
said, I don't think I would object to, I mean, they'll have an opportunity through cross-examination, and I don't think I would object to them having an opportunity to put in some sort of response.
As part of their cross?
They're, as part of their cross, or,
Yeah.
yeah.
Okay. Ms. Meserve?
Good morning, OSHA Reserve for Land. Yes, there was a reference in the motion for reconsideration about some DWR not being allowed to put in evidence. And I just want to clarify, my understanding of the record is that from all the way from part one of this proceeding, CCLP has been putting in evidence and talking about the way in which their farm has experienced the California, the DWR and the Bureau of Reclamation's existing facilities, and then their concerns about the facilities that are petitioned here. So that has been very much at issue throughout this entire proceeding. DWR has had multiple opportunities to put forth evidence about its side of that story, and in fact, it has put forth a certain piece of evidence about that. So I strenuously object to some insinuation that there's not an opportunity. And then I would just follow up with Mr. Emmerich that yes, cross-examination right now, through cross-examination exhibits and otherwise, that certainly seems like fair game as long as it's within the scope of the testimony. So I don't see any unfairness here.
Excellent points, Ms. Meserve. A response?
Yes, actually, that is not correct because these issues have been outside the scope of this hearing up until this point. And as I understand the ruling, the seepage issue, because it was not related to WaterFix. As I understand the justification for allowing these issues that are outside the scope of the September 10th hearing to come in, it's not to show that those things existed, but rather to insinuate or imply or to allow that insinuation that DWR will not follow through on its mitigation. And DWR has not had the opportunity because these things did not change. These are existing conditions to put that into the record throughout this proceeding. And these issues, I assure you, are much more complicated and nuanced than is being presented by only one side.
What are the existing conditions? Is that a later thing? Okay.
Ms. Desjardins?
I would just like to point out that petitioners are proposing to construct a new reservoir in the same location. And I think if the board was going to consider, for example, what conditions they might put on construction, and Dr. Tom Williams did have some testimony about that, it has to do with public interest in evaluating the
I'm sorry,
commitments.
Ms. Desjardins, you have lost me. How does this relate back specifically to Ms. Morris' motion for reconsideration?
Well, seepage, whether
I don't believe,
The DWR has promised to deal with seepage for the new reservoir, for Byron Tract 4B, with future design. And I think it's very important for the board to consider, because that is a future commission. We don't have anything about the design or how.
again,
we do it.
that was not Ms. Morris. Mr. Emmerich, any final words on this?
Again, I think the final word is that because of the way things have progressed with changes to the project, we now find ourselves in a situation where we have the right, I believe, to present rebuttal that would go to promises and representations that DWR will follow through with what they're promising they will to hold us harmless from the new project. And I think it's very instructive as to the situations that have occurred before with respect to CCLP and DWR. They have cross-examination. They can ask those questions, and I don't know if perhaps even allowing them an opportunity to supplement the record to respond rather than throwing or keeping our testimony out.
Thank you, Mr. Emmerich, and thank you for trying to be helpful. With that, we will take another break. All right, we are back. And Ms. Morris, after consideration, your request for reconsideration, it is denied. Our ruling stands that based on petitioner's portrayal to date, that they will address any impacts, that they are to be trusted. We find Ms. Womack's CCLP's testimony responsive to that, and we will hear her argument. However, DWR petitioners will have the opportunity to conduct cross and establish your various arguments with respect to the testimony Ms. Womack and Mr. Moore will provide. And should you wish to request additional time to bring back a rebuttal to this rebuttal, you may make that request as well. Before we proceed, though, there is a clarification with respect to our seepage, our prior ruling with respect to the issue of seepage. There might be some misunderstanding, and so I'd like Mr. Derringer to clarify and remind parties of what that ruling was.
So our current understanding of what the hearing officers have ruled is that what they've excluded is evidence about the following. During earlier iterations of the project, there were seepage issues that the petitioners were proposing to correct, that as a result of changes described in the administrative draft supplement, they deemed no longer necessary. So there were issues being fixed that were then not being fixed, just to put it very colloquially, alleged issues, if that makes it better. And that we said that those aren't impacts from the project. Those are things that we're proposing to be changed that are now no longer being changed. That is different than saying that were flooding issues all along, there were seepage issues all along, that CCLP was not affected by when its property was being taken, that now that its property is no longer being taken, is very much affected by. It now has a property interest because of changes in the project that it didn't have before. And so this is now their opportunity to ask questions about those changes and those impacts.
Ms. Morris.
On behalf of the state water contractors, I would, based on my understanding of previous rulings, request that I be allowed to conduct cross-examination of this panel on Monday, because given the scope of these rulings, I'm going to need to pull several documents that are related to not only the seepage settlement on this property for the original contract, but as well as many communications back and forth on these other issues. I also would request that the state water contractors and the department be allowed to bring a witness from the field division to discuss this, because essentially now this has turned from something having to do with California WaterFix project into a trial on DWR's character. And unfortunately, we would need to be able to have time to respond to that. And I don't think, given the complicated nature of these issues, because there's really twofold. On several of these issues, there's legal agreements that are existing. There's debates about who owns things. There's probably about 5 years of correspondence back and forth on this drainage pipe issue, to the point where the DWR field division had to say they're going to fix it.
Now you are testifying.
I'm not testifying, but describing the complicated nature. It's not a simple issue. So I would request that DWR and the state water contractors bring a witness back no earlier than a week from next Monday, so that we have ample opportunity to pull together all of that information, since it is a change in the scope of this hearing.
Hold on, Ms. Desjardins, please step back. I would assume that DWR is going to join in on that motion, so let's hear from them first.
Yes, Trip Mizell, DWR. We would join with the state water contractors motion, but I'd also like to ask for a little bit further clarification from Mr. Derringer, if you might.
Could we hold on to that thought?
Yes.
Okay. Mr. Emmerich, let's hear from you first before we get to Ms. Desjardins, and I assume Ms. Meserve also would like to speak.
I'm trying to clarify a little bit of what Ms. Morris is asking. I think what she suggested was that the cross-examination for this panel be moved to Monday, and then, if I'm correct, and then that they have an additional opportunity to bring a witness in on their own at some later time.
That is my understanding of her request.
I don't think we would object to that so long as we get the information, Okay.
We've got appointments both Mondays.
Okay, so when would,
We've got a heart specialist and we've got a bone specialist.
how about October 4th or 5th, would you be available?
I will have to, Dad, are you?
But that's my understanding, and I don't think we'd object if we got the information, the cross-examination information ahead of time.
Okay? And is this specific to the request that has been made?
Yes, it is. I just wanted to point out with respect to the field division, I had subpoenaed the engineer from the Delta Field Division to come testify about his evaluation of Clifton Court Forebay and the report that he had.
Let's not,
And
no, hold
that
on.
was quashed.
Hold on.
Yeah.
I only want to hear about the specific requests, whether you are objecting to it or supporting it. I do not need any further offers at this time, Ms. Desjardins.
So for that reason, I would object to them now saying that they want to bring somebody in from the Delta Field Division to testify because the subpoena was quashed.
All right, Ms. Mazur?
If I'm not mistaken, this issue was addressed, seepage was addressed in Part 1, and DWR submitted the testimony of Alan Davis, DWR 935, and several exhibits that specifically address seepage. So the idea that DWR hasn't had the opportunity to think about and respond to seepage issues earlier, I don't think is correct. And there's also some exhibits that have a settlement agreement and other things like that. So I think that we submitted, and Ms. Womack as well, submitted her testimony when she was supposed to. We've all been on a really quick schedule that I have complained about, but I don't see why DWR should receive additional time to think about something that they've had in hand, just as long as the rest of us have had. And I had asked also for DWR to have the same amount of time as DWR now has on Clifton Court to respond to the testimony that DWR put in just last Monday, and that was, and they're apparently going to be testifying today. So I think if you start allowing more time for different parties based on some perceived unfairness that I don't think exists, I do have an objection to that.
Anyone else? Ms. Morris, do you or Mr. Mizell like to respond before we move off this topic?
Certainly. The department has not presented information on seepage that goes beyond the California WaterFix. Despite the arguments by Ms. Meserve, that hasn't been the case. Furthermore, we have not presented any information about the diversity of claims against the department that have been made in CCLP's testimony here for SIR rebuttal. So we disagree. We believe we do need an opportunity to respond to these additional issues that are now within the scope. And let me know when you want me to ask Mr. Derringer the clarifying question about the scope ruling.
Actually, I need to ask you a clarifying question. I'm looking at DWR 935, SIR rebuttal testimony of Alan Davis, which responds to CCLP and responds to the seepage problem she cited in CCLP 30. This was a while back. In what way do you believe that there is additional testimony DWR needs to provide to respond to CCLP and that you did not have the opportunity to before?
Up until this point, the existing conditions that will be in place, whether or not the California WaterFix is approved, have not been within the scope of this hearing. Today marks a change. Today, we are now opening up this hearing to a number of topics that will exist regardless of what you determine about the California WaterFix. That is a distinct change in the scope, and we have not yet had the opportunity to address existing conditions that will not be modified by the California WaterFix. The testimony of Alan Davis, if I recall correctly, was not entered into evidence. I don't believe he appeared, but I would have to go back and look at my notes. That was a long time ago.
Mr. Mizell, let's be, and again, this is a complicated area that we're trying to clarify here, but when we're talking about opening this up, we're specifically addressing CCLP's situation because of the change that was proposed for this project, given the administrative draft, where you proposed to no longer utilize her property. That changes the baseline that she needs to consider when she performs her impact analysis and her impact arguments to us. So our reopening any issue with respect to existing conditions is as a result of the project change, which then raises new concerns for her, which she did not have in part one.
And this goes to what I was hoping to clarify with Mr. Derringer. If the opening of the scope today is based only upon the fact that we have decided to not pursue a Byron Tract forebay on Ms. Womack's property, but instead to move that to the north, then the opportunity to respond to that change should be limited to the impacts that the California WaterFix now presents to Clifton Court forebay's property. That does not include existing conditions. There will be no change in the existing conditions that Clifton Court forebay experiences by virtue of not taking her land. So when we are talking about what we're expanding the scope to consider, I think it needs to be extremely clear as to, are we talking about allowing testimony on conditions that will exist regardless of your decision in this hearing? Or is it only impacts that will occur if you grant the petition? That is the cornerstone of whether something is relevant or not, within scope or out of scope. That's what I'd like some clarity on.
Ms. Morris, anything to add?
Testimony of Al Davis, if you look at it wasn't ever submitted, it wasn't brought into evidence, and it was focused on the seepage issues with the cutoff walls when the project included the forebay on Clifton Court, not on Byron Tract. And again, I just want to clarify, because we do seem to be confusing issues a little bit here. My understanding of the ruling of why these other issues, including existing seepage, the drainage pipe, the 4 pumps agreement, were relevant to the hearing officers, was based on an implication that DWR won't do what they say they're going to do, and therefore they were within the scope for this proceeding. And those issues have not been addressed ever, nor has that ever been clear that that was a concern. And so it's only fair for the department
Ms. Morris, Ms. Womack has brought those concerns up since the pre-hearing conference and throughout phases 1 and 2.
Right, and up until today, those have been outside the scope of this proceeding, except
I don't believe we've ever ruled that the trust issue is outside the scope of this hearing.
I believe that if
you would need to point me to a specific ruling from us that says that.
I didn't say that it said the trust issue was outside the scope. What I said was that if these things are to come in to show as evidence of DWR not to be trusted, then DWR should have the ability to respond to those specific allegations, not to the general trust me allegations, because general trust me allegation, there are legal obligations in these documents that we have pointed to throughout in terms of mitigation, and those respond to the allegations related to this project. These other issues are different because they don't respond to this project or to legal obligations of this project. They respond to things that are outside this project and this project's impacts. And that's the difference.
Ms. Desjardins.
With respect to the argument that Mr. Mazzell made, it's been clear since the beginning of this hearing that Ms. Womack was talking about property damage and injury to her property. And it's also clear that there's issues of personal injury or death. The final EIR-EIS and the supplemental EIR-EIS all talk about property damage, personal injury, and death. There is a very clear due process right with property interests and interests in life in this proceeding. And I think that petitioners made a legal error in their strategy, and they're now trying to claim they did not have a chance to address these issues. They are in their environmental documents. There was clear testimony in part one that these issues would be dealt with in the future, and now they're not. And petitioners had every opportunity in their part two case in chief to have any indication about how they would deal with this, and they just declined to do so. Thank you.
I see Ms. Meserve coming up, and then Mr. Emmerich, I will give you the final word before we take yet another break.
Sorry, I was trying to catch up on kind of the factual matter. And yes, it looks like although Mr. Allen Davis's testimony was never submitted because he wasn't available, according to the July 7th, 2017 ruling, all the exhibits that he chose to submit in support of DWR's position, at least in part in response to the seepage concerns, were part of evidence. So all that evidence is in the record. Thank you.
Mr. Emmerich.
Yes, I certainly sympathize with DWR. I do, the strategy obviously was to make an objection, and so that this information, this testimony wouldn't be submitted. And in doing so, it appears that DWR didn't prepare for cross-examination on these issues. That's certainly not our fault. But with that being said, I think we would still be open to the possibility of moving testimony and cross-examination to another date. But we don't know what those dates are.
Right. I have I've got old people appointments. I've got a heart specialist. I've got we've planned for this day as far as giving our testimony. My father doesn't have to be here after our testimony, but we've done a lot of things with 90-year-old people so that he could be here today. So I would hope you would respect his time. And he is the expert that can speak back to 1967, 1968. I don't,
right.
He said most people weren't born.
All right. For the record, Ms. Morris, DWR 935, Mr. Davis' testimony was admitted into the record pursuant to our August 10th, 2017 ruling. With that, we will take a break. right, thank you everyone for your patience. We did take the time to consider all the information provided as well as review our previous rulings, and I have 2 corrections, or at least revisions anyway. The first is with respect to Exhibit DWR 935. I was mistaken before. Apparently, DWR withdrew Exhibit 935 because Mr. Davis was not available. We took official notice of many of his exhibits, and in fact, we did admitted most, if not all, of the exhibits associated with Mr. Davis' testimony. So that is in the record. Secondly, with respect to Mr. Meisel's, which seems like hours, if not days ago, first objection regarding CCLP 60, page 9, line 15, through page 10, line 3, regarding the discussion of seepage as an existing condition being outside the scope of SWR rebuttal. That objection is sustained, and I will leave it to the attorney to explain why.
Thank you, and my apologies. This one's on me. I was misreading the scope of what was being described in this section. It does indeed refer to conditions that would exist irrespective of WaterFix, and that's the hearing team, and that I understand the hearing officer's reading of this section.
Then we also have Ms. Morris' request to conduct cross-examination of this panel on another day. Ms. Womack, are you able at this time to let us know when you might return?
I'm available until the 9th, but my father has many doctor appointments, and he doesn't know, and he can't call my mother to find out. It's unfortunate.
Ms. Morris?
I'll withdraw that, but I would not withdraw the request for the DWR witness as to the other issues.
All right. So Ms. Morris, I'm sorry, let me make sure I understand. By withdrawing it, are you proposing to conduct cross-examination today?
Yes.
Okay. Ms. Morris, we will take your request to present an additional witness under consideration. We will issue an order on that request early next week. Is there anything else I need to address? Apparently there is.
So depending upon the scope of what Ms. Morris is planning, it would be my notice calling the Delta Field Division engineer was quashed based on that Ms. Womack could have presented it earlier in the hearing, and I would request to renew that if DWR is being allowed to bring in new witnesses based on that the scope of the hearing was somehow expanded or changed. Thank you.
We will take that under consideration. Okay. Only 2 hours later, Mr. Emmerich, Ms. Womack, Mr. Moore, if you would like to present your SWR rebuttal testimony.
Yes, I'll turn it over to Ms. Womack.
Okay. At the beginning, I'd like to say there's 2 minor typos on page 6, line 2. It says isolate instead of isolated. And also on page 6, line 14, I say DWM2 instead of DSM2. I believe those are the only typos, but there's one other thing. I refer to testimony and transcripts. I go back and forth because I'm referring, when I talk about the date, I'll say testimony, and I'll put the date. I think it should say the transcript. So should I change that out? Is that necessary?
No, we'll just make a note of it. Thank you.
Okay, I apologize. Anyway, my secretary's not very good. Okay, I hope you don't mind. I'm going to read this because I am so flummoxed at this point. It shouldn't take too long. The summary of testimony, and I will leave out the qualifications because we've gone through them quite extensively, and I know they will go into the record. Not the summary, just the testimony. Okay. You sure? Okay. Testimony then. When Clifton Court LP reviewed the supplemental EIS, we found it difficult to respond to the SEIR-EIS because we did not understand what was happening to our water rights, and therefore...
I'm sorry. Are you proposing that you're just reading your testimony?
Well, that's what I did in SIR rebuttal in part 1, and so I want to make sure I get things in.
Things are in.
Why did I read it in SIR rebuttal? I've been practicing since part 1. Part 1 SIR rebuttal we had to read.
I'm confused now. It's been our practice to discourage witnesses from simply just reading
Okay,
what they provided in writing. If what you're reading is a summary of the testimony you provided, then yes, please proceed. But if you're just reading directly from the testimony...
Well, okay, what I will summarize as I go, but what I found, I know I had to read in on the SIR rebuttal. I remember that because it threw me then. Anyway, okay, so basically that, in August, in 2016, DWR announced that they were going to take all our property, and then it was only in July, I think it was 5th, ruling that DWR expressly told us that they weren't going to take any of our property, nothing. And that's when we started to look carefully at the proposed project, at this control structures and all the other things. And we found out we believe we still are injured by, as the CWF will still injure us as a legal user of water. During the testimony, Mr. Valle's testimony, he clearly made reference that we didn't know you had pumping out in the channel, in the DMC channel. It was very clear. And, you know, that kind of scared us, especially since the petitioners, DOI, were the ones that gave us the cleanest copy of, we have the 1955 contract with the Department of Interior that was given to us when the, basically when they put in the fish screen, they took our Clifton Court's floodgate that used no electricity or anything, and they put our riparian and all of our water, riparian licensed, everything was put in the middle of the DMC intake at a point that that Department of Interior said it would go to. And in 2000, my father, like I said, with CalFed, they were working with my father and they brought in this contract. So clearly, Department of Interior is very aware of this. This water diversion has turned out to be our most vital of the farm's water because of different things. We tried putting something in front of the Tracy fish screen to get another water source, and that did not work with all the water hyacinth. That's the control structure on the DMC has gone from 2.2 to 14.8 acres. And when we asked how that control structure gate would work in relationship to our diversion, Mr. Valle said that will be determined in the future with the operations. I don't have an answer for you. So he said there was not an answer. And then Mr. Chill McCurry said there's no modeling it appears the control structure is on and within the DMC intake channel. And so our modeling does not address the changes in those in that channel. This was what was said on 810 during the testimony of Mr. Chilmacurry and Mr. Valles during cross. And because there is no modeling or analysis of how the control structure affects CCLP and our diversion, we have no way of looking at the impact on our control structure, the control structure would have. I should mention at this point that our contract says that we have unlimited right to be able to go to our pump by the shortest version, and that is via the roadway on top of the DMC intake. That is something that it concerns us about construction. I would imagine that the construction of the control structure is going to be fenced, but I will be asking Mr. Bednarski about that. Anyway, the next part is the isolated North Delta operation, which we only found out about in the CER. And only the Byron tract is used in this scenario. And there was unfortunately, DWR had said that there was gates at the Tracy Fish facility and the gates would be closed. And Mr. Valle said, no, there are no gates at the Tracy Fish facility. We were aware of this, but we wanted to make that clear from what DWR had said at DWR 1304 5-6, 5.1.6.2. Anyway, Mr. Valle in his testimony clarified that. So when we asked Mr. Valle how we'd access our year-round water, we were told we would find out later from Mr. Mazel. And we wrote questions and we were supposed to get a response the Tuesday after 8:10, and we did not get a response to how our senior water rights. We've written questions. We have not gotten answers to those. And we also had questions in writing, in our testimony writing, regarding what would happen to our diversion if the control gates were closed under the isolated North Delta operations. And we'll be looking at that today with Mr. Bednarski. But when we're trying to find out what is going to happen with these operations. And so basically with the isolated North Delta operation, they will be shutting down the control structure. And we asked if there was modeling, Mr. Emmerich tried to clarify with Mr. Chilmacurry. And he said, Mr. Chilmacurry, when asked if there was modeling for this, he said the modeling I was referring to is the DSM-2 model, and it does include the intake in general, but not the specificity. We need to, it's late in the day. We need to analyze Ms. Womack's diversion. So he says very clearly here that they don't have the modeling. We believe that any obstruction of the DMC intake will injure our senior riparian year-round license contracted water, and our contract is with Department of the Interior. They promised to bring the water, convey and transport the water to us. So the potential dual operation with the WaterFix BTO, and under the dual source operation scenario, the control gates will control flow out of the BTF, the CCF, and the Old River to meet the target deliveries at both Banks and Jones. The control scheme will require flow meters, WSE transmitters, in other words, the water levels, what's going to happen, and then this sophisticated system downstream of both Skinner and Tracy Fish facility. And they say that downstream of there, they're going to have a lower WSE. Anytime our waters are lowered, it causes problems. It costs more for our tenants to pump. And higher pumping costs, this is caused by low levels. It can also lead to destruction of the pumps, which has happened on numerous times. The one thing we want to make clear is that let's see, that right now we have tidal water. Our farmer can look in the almanac, know when it's a high tide, look at the Tracy Fish facility, see if the trash racks are in bad shape. He can tell what's going on, and he can pump at his cheapest cost. Once the control structure is in front of our, which it's recent information where they're now saying it's 100 feet in front, the control structure, and then our intake is 100 feet. Once that's in, we won't know when the water is going to go up or down, because that's all going to be done through this very complex SCADA system, which I've read about a little bit, but I'm looking for much more detail on, and as far as I can tell, it's not there. In fact, it says the location and design of structures capable of operating in a dual source scenario need to be explored in further design phases of the project. Such work will refine the configuration of facilities necessary to achieve the mode of operation. This is DWR 1304 5-6. So they're talking about doing a dual operation with the WaterFix BTO. But then they say, well, we really haven't designed it. We're gonna do it. So I just don't know. I know my water levels will go up and down. That's very clear. In fact, where is that? Well, anyway, we asked Mr. Chill McCurry about this. How will the dual operation affect my pumping levels? I depend on tides now. Will this change my water, how I get my water? And witness Chill McCurry said, again, the modeling I'm describing does not take that into account or cannot be used to analyze that when we talked about water levels due to the potential dual operation with WaterFix. So that's from the testimony. Next, we move on to the South Tunnel and South Tunnel outlet structure. Mr. Long, is it possible to, I believe, DWR 1305 PDF 84, and I believe it's 85. One is the picture of it and one is the map. So when I asked if there was any studies and modeling that show how the diversion in the DMC intake will be affected by these structures, the South Tunnel and South Tunnel outlet structure, Mr. Valle stated that modeling has not been done, those studies have not been done. We believe this structure will greatly affect the whole operation of the BTO and the dual facility. Is that just not coming up? I think it's, yeah, I know it's DWR 1305 PDF. Oh, okay, oh, that's the control structure. Okay, is that 84? Okay, could you go one page back? It's either one page, okay, one page forward? No. Okay, one more page forward? Yeah, that's okay. Those are the control structures. This is not, okay. Oh, okay.
Are you trying to show
The channel? I wanted to show the, actually, no, 13, where is it?
That's what you're trying to show?
No, no, no. I wanted to show. There it is, yeah. That's it. So we believe that this operation, and then I believe the next page shows the actual where this will, yes, thank you so much. Whew. So this shows then that this operation goes into Banks and Jones's intake. We call it the DMC intake. But that control structure we've talked goes right in the center there, and then there's another control structure on either side, and there's a control structure in the Banks intake, and ours is, you can't see on this, but this is a 127 acre structure and channels. This is a huge thing. We think it's going to affect what happens with the water here when the water comes in. Sometimes what I've read is that the control structures, and I'm not sure if they're the ones in this yellow part, there's two, one on either side. If those are going to be half open or all the way closed, there's just this whole unknown. And I believe very strongly that that huge opening into the channel, and just above the Byron Highway there is, just a little ways back, is our control structure. I think this is going to affect, in a big way, the water levels in the DMC. So, according to Mr. Valle, the modeling has not been done. Certainly no modeling on how it affects my diversion, because that diversion, again, is not talked about. And I think we need to be able to see impact reports to be able to know how we're going to be impacted. I don't want someone's opinion. I want facts of how these operations of all of these facilities will affect the flow in the, what I call the DMC intake, and what it's called right now. It's not Jones Channel. So I'd also like to look for a moment at, with the control structure, I'd like to look at, I think I passed this earlier, DWR 1305-87, because I think that will help. 87, 88, and 89. So this is the control structure. This is the control structure, and we think this, there's talk about whether this will affect us. This, and when those gates are all open, so there's talk, will that affect us? And they compare it to the no action alternative, which would have nothing in it. And they say those two things are the same. And I'm very confused how you could have this huge facility here. And this shows that this is not the DMC, this is just a rendering. But how you can have that, and then if you could go back, Mr. Hunt, I'm sorry, not Mr. Hunt, Mr. Long, not that page, the page before, because this shows how they work. The structure, the control structure plan, I'm not sure how that kind of, it looks like it's a timer on its side. I don't know how big that is, how many acres, or how, there's nothing that shows how big this is. The only thing I have is that rendering, so I don't know how that's going to affect if my diversion is on the other side. So those are things we've wondered about. So I should move on. But I forgot to bring that up. So the implications of the WaterFix BTO on the current SWP and CVP operations is the next thing. There's been quite a bit of controversy in different writings I've received and then not received that have been taken away from me, that the CCF is not a part of the project. But in the CER, it's abundantly clear that the State Water Project has Clifton Court Forebay, Skinner Delta Fish Protection Facility, and Banks, and that the CCF has Banks pumping, and the Banks connects to the Clifton Court Forebay. The Jones pumping plant is the end of the 2.5 mile that starts at Tracy Fish Collection Facility. And at this point just has the Tracy Fish and the pumping plant 2.5 miles away. It's a tidally influenced channel. This is what we're dealing with right now. Now the BTO is going to change it. They're going to remove the tidal influence. They say that in DWR 1304 5-14. We know that already it's hard enough with the tidal influence to understand when the waters are going to drop, but we cannot know if it's where the tides are the water levels are going up and down because of something other than tides. And this is what with the ramping up and down of deciding which water is going where. The water from the BTF will require a daily level of operation between DWR and reclamation. And given the fact that they don't even communicate now that one has this one that we have the intake that is a federal contract from 1955 that DOI and DWR can't communicate. We're very worried about how they're going to communicate, and there don't seem to be any operational plans in the SEIR EIS. And we think we'll be injured by the poor communication from DWR and DWS and reclamation. The common scheduling of the individual pumps will need to manage the WSE. Again, that's the water levels and the volume in the BTF and the CC and the Clifton Court forebay. They're going to be common scheduling to decide who gets what. They don't know what that is as far as I can read. I have not found it. It's going to affect water levels. It's going to affect Clifton Court's diversion. Liquefaction. Available subsurface information indicates the potential for liquefaction exists along all the sides of the existing Clifton Court forebay. We're worried about our tenants. For the purpose of conceptual design, it's assumed that this analysis is valid for the Byron Tract forebay. We would hope that liquefaction does not, that CCF and the Byron Tract forebay will be equally taken care of so that liquefaction does not occur. And things will be brought up to the 2020, not 1960s. The flood protection, you're telling me, can I do flood protection? Is that, what do I do on the flood protection? Because I'm talking about, I'm not talking about seepage here, I'm talking about desiccation of not meeting the flood standards. This has nothing to do with seepage.
Mr. Mizell, are you making an objection?
This is the section that you revised your ruling on just before the presentation of direct, so we would object to oral testimony on this section.
If it doesn't concern seepage, though, is it?
I believe this was part of, if you could identify where it is, it might be helpful to us.
Oh, I'm on page 9. I'm sorry.
What line, please?
Flood protection. Starting with 16, where the DWR states the conveyance facilities are considered to be a critical lifeline facilities for the state of California.
I believe we struck page 9, line 15 through page 10, line 3.
Okay, so, but that was for seepage. This is not seepage.
We clarify, attorney?
Those lines of testimony were stricken in their entirety, regardless of subject matter.
Not to do with seepage, got it. Okay, we'll go on to operations. There, according to the SEIR EIS, there's no new operations, and we are very worried about this. On September 19th, I got a call from my tenant farmer telling me that he's unable to use his water rights due to DWR DFD operations. Our tenant was told by a DFD employee that DFD was replacing their 50-year-old leaking drainage pipes from the 12th of September to the 14th. It should be noted that the crew in the field didn't agree that this would happen this amount of time. Should be noted that Clifton Court LP was never contacted, nor have we signed anything. Our farmer tried to be helpful and uncoupled on our side the drainage ditches, and we would not have advised that. So without any authorization from CCLP, the drainage ditches were taken out. My farmer thought he would begin watering. He's putting in his next crops September 17th. As of today, they are still not in. We might get one pipe in soon. He wasn't consulted from DFD as to when we would replace this pipe, and we were not notified, the CCLP, or I think we should have had a signature. We'd write this off to bad luck, except this leaking pipe debacle has been going on for well over a year. This is the most recent example of how DWR DFD operations of their SWP property affects CCLP water rights. Apparently, this team will continue operations with CWF, and I wanted to give a brief example of how this has taken place. So if I could have CCLP 40, we start with a letter from DWR DFD telling us that we, first of all, okay, I'll wait till it comes up. Could you shrink that a little? First of all, I'm told that I met with this person. I never met with them. And what bothered us too is this is not on DWR DFD letterhead. So we received this saying we'd met with them and we'd agreed to replace and fix the leaking drainage pipes on DWR property. And they temporary. And then if we go to CCLP 65, we write a letter back as soon as we receive it and say, what are you talking about? The leaky drainage pipes are their property and are theirs, and it's their responsibility to fix. And as my father so smartly said while we were waiting, we don't have a right of way to be on this property. And so after this is a year ago, after that, the 30th, could we go to CCLP 67? So, we basically say this, that must be...
I'm sorry, I think you mean 66.
Oh, yes, I did. I'm so sorry. Trying to hurry this along. So 66, we get a letter back. Now it's from DWR saying, oh, and this is the person I'm supposed to deal with because DFD won't deal with me. Be advised, all drainage systems equipment located on DWR property, specifically what you describe as South Bank of Clifton Court Forebay, is in working order. There's only one drainage pipe. That one, there's two, but right that one location, that's it. So they've been leaking since August 10th, 2017, our last letter. Oh, no, they weren't. Sorry, August 30th, they say they're not leaking. And so now, the next picture is 67, CCLP 67. They decided to try to fix it. This was taken on my son's birthday, July 31st, 2018. And I say it shows it's leaking. There's a little bit of leaking, but it also shows the seepage. That is seepage. I have other pictures I'll show in a minute, but that's seepage from underneath. But this is where the pipes, they're 50 years old. They need replacing. I don't know why they stopped in July. There's just all of a sudden, we started up again. But, then on, let's see, then if we go to, then if we go to September 12th, 2018, DFD begins work without contracting landowner and tenant, has the tenant farmer uncouple the drain pipe on the CCLP side. My farmer thought that it had been approved. We're alarmed by the lack of legal communication and coordination. And we're also alarmed that now, that was on the 12th, they're at the 28th, that's 16 days not being able to use our year-round water right. My farmer, it's going to rain this weekend. On the 15th of September, we wrote to Catherine Kavanaugh, who we've been told to write, and CCLP 68, sorry, thank you. And we also sent a letter, we CC'd that same letter to Carly Newman, the head. So this basically says, these are your pipes. We've had this problem for a year. You know, I took a picture of leaking pipes in the 31st. You've taken out during the heart of our farming time. We can't do this. I don't know if my farmer is going to be able to put in his crops or not. I have a letter from him and another picture of the uncoupled things. This is affecting his livelihood. And I don't know when this is going to be finished and fixed so that he can actually farm. Once it starts raining, it could be hundreds of thousands of dollars worth of damage. And when I spoke with Ms. Kavanaugh and I said that, she said, well, you can sue us. It makes me cry. My farmers are up against enough without having to not be able to get when you irrigate, you have to drain. You can't irrigate otherwise. That's how you do it. My dad said, I'm an ag science. My dad knows all this. I don't know if other people understand as much. I know you do, Tam, because you're an engineer. But basically what's happening is that we're being ignored, and we're just, why would you take out in the middle of summer? Why would you take out your irrigation? Why wouldn't you ask the farmer? Why wouldn't you get permission from the landowner? I'm just about done. I'm so sorry. It just upsets me so much. Anyway, and our main thing is, if DWR DFD is unable to fix a simple leaking drainage pipe in a professional, competent, timely manner, how are they going to fix the problems that come up with this huge project? This is a 1950s, 1960. This is a simple drainage ditch.
Ms. Womack, I need you to wrap up.
I am. Let's see. So they want CCLP to believe their control structure and the south tunnels and the south tunnel outlet structure and the complex WaterFix BTO operations and all these other things that they're dreaming about will not injure CCLP's water rights or our 1955 contract with the Department of Interior. We don't believe it. But we don't believe petitioners are able to create and maintain their CWF project without injuring CCLP water rights. We believe petitioners' continued inverse condemnation as shown in our exhibits will only increase if they're allowed to take or move our diversion in the DMC intake. We wish to be made whole. We ask that as a part of a condition of the permit term. The petitioners be required to compensate CCLP for the loss of use of its property and corresponding damages resulting from the CWF project as set forth by CLP, or in the alternative, purchase all of CCLP's property. This should be required before DWR begins the project so that DWR can determine how to operate the CWF without injuring CCLP water rights and our contract with the Department of Interior. Thank you.
All right, thank you.
Oh, did you want to say anything, Dad?
You did use up your time as well as his.
Okay, that's fine. No, he's fine.
But if Mr. Moore would like to make a brief addition?
Are you okay? He's okay. Thank you. Thank you so much. I appreciate the extra time.
That takes us up to the noon hour. I had previously received estimates for a cross of 10 minutes by state water contractor and DWR. Is that still the case?
Based upon this morning's argument and rulings, I believe we'll need more than that in order to conduct cross-examination today that covers the scope of the rebuttal testimony.
And how much time do you anticipate needing?
I would be able to give you a more precise answer after the lunch hour, but I would initially anticipate 40 minutes.
Right. So we are going to have to ask you to come back after lunch. Before we break for lunch, though, since I see Mr. Worth here, and I'm desperate to see his photos, I had originally received no requests for cross-examination of Mr. Worth. If that is still the case, then I will allow him to go before we take our lunch break. If that is not the case, then he too will have to return after lunch.
I do have some objections that I'm happy to lodge, and then we can go to lunch. But I do not have questions, and depending on whatever testimony stays in, obviously we don't need to question Mr. Worth.
Okay. Hold on, let me hear from Ms. Desjardins first.
Yes, I was not here, and I did have some cross for witnesses today. I just wanted to ask for 10 minutes to reserve 10 minutes if needed for Ms. Womack. I don't know if I'll need it or not.
That was 10 minutes for Ms. Womack. Did you have any cross for Mr. Worth?
I don't believe I do.
Okay. Let's hear Ms. Womack, Mr. Moore. If you would like to leave for lunch, please do so.
Right.
We will ask you to come back for cross-examination after our lunch break.
Okay, can you do that, Dad? Can you hang out a little bit longer?
And
Okay, thank you.
Ms. Ainsley, let's hear your objection to Mr. Worth's testimony. Hopefully it's not to his wonderful photos. And Ms. Meserve, if you could please come up and be prepared to respond.
Yes, and I've endeavored to cut it down. I tried to read the transcript from Wednesday, and obviously I've been trying to listen, so I apologize.
Microphone lower, please, Ms. Ainsley. Thank you.
And I think that the gist of my objection would be, looking back at your September 10th, 2018 ruling, would be that in large part, Mr. Worth's testimony is repetitive of his testimony in the rebuttal phase, which was SOSC 80, where he provided extensive testimony on project changes in the administrative draft EIR, which included noise impacts in the administrative draft SEIR. And so again, what we have is Mr. Worth providing testimony on impacts in the administrative draft SEIR, and also including specifically also noise impacts in the AD-SEIR. The second level of my objection, so that would be my first objection, is that I find this to be repetitive testimony and merely a continuation of impacts that he alleged in SOSC 80. And I believe that there are plenty of sites throughout this testimony to SOSC 80 that makes my point for me.
Ms. Ainsley, my understanding was that he was also responding to Part 2 rebuttal testimony of Dr. Earl.
Yes, and that's what I'd like to get to right now, just very briefly. And I have cut this down to focus specifically on avoidance and minimization measure 20, which is page 3, line 24, through page 9, line 16. That section is a section titled Avoidance and Minimization Measure 20 is ineffective. He does begin this section by saying that Dr. Earl and the AD-SEIR both heavily rely on the conclusions of the FEIRS. The bulk majority of the testimony on the pages I just cited, however, are a criticism of AMM 20, sort of independent and free, for the most part, of any changes in the AD-SEIR. They are a critique of AMM 20, which has not changed itself throughout Part 2. There are a couple small exceptions in there where he does reference the construction schedule of the conceptual engineering report, but again, the bulk of the critique of AMM 20 could have been brought at any time in Part 2. So that would be, I consider, outside the scope of SIR rebuttal, and going specifically to noise impacts and impacts of the AD-SEIR, I would call that repetitive with his SOSC 80. And I'm sorry if I garbled that, since I wasn't quite ready to go right now.
No, actually, I understood that.
Okay, thank you.
Ms. Meserve, your response, please.
Thank you. The testimony is within the scope of the September 10th ruling. It is responding to new information in both the supplemental draft EIR as well as new information in the CER, which was first provided in DWR's Part 2 rebuttal testimony. Mr. Worth was careful, actually, to try to avoid being repetitive of prior testimony and simply to refer back to that in citations. With respect, so all of the testimony is trying to focus on really what are items 1 and 2 in the September 10th order, and which includes, as you mentioned, the testimony of Dr. Earl. And the reason why this testimony is appropriate now is because DWR has made some footprint changes to the project that change where impacts would occur, and in the focus of this testimony is to sandhill crane, although some of these things would be applicable to any wildlife, which is certainly a Part 2 issue. And the SEIR, the admin draft SEIR, repeatedly points to AMM 20 as being the means by which these impacts would be avoided, and in our parlance here would not be unreasonable. And the admin draft SEIR does not attempt to try to analyze the different changes on the landscape, including some really significant changes and increases in certain types of crane habitat in relation to the noises and other impacts associated with the project. So while some of the impacts of the project may remain the same, the testimony is centered around the idea that the impacts on the particular landscape are different, and pointing to DWR's failure to analyze those in the SEIR so that they can be understood in this hearing. And in addition, the continued pointing to AMM 20, which has not been revised at all, as the means by which those impacts would be avoided. So I don't think it's the burden on protestants at this point to try to parse out every single little thing that may be different. And we, in fact, are responding to this new information and how the mitigation and avoidance is ineffective. Thank you.
Thank you, Ms. Meserve. That actually was my understanding, and when I read Mr. Worth's testimony with respect to AMM 20, that he was applying it to the new footprint in the ADS-EIR.
And I guess in response, I would argue that that is I found this to be a pretty thin hook. I did not move to strike Part 2 of his testimony, which is the ADSR fails to address substantial changes in the footprint. But if you read Section 3 of his testimony, after his introductory sentence, which he says relies heavily on the conclusions of the FEIR, the majority of the remaining testimony regarding AMM 20 is critiques of AMM 20 that are independent of the ADS-EIR because they are unchanged throughout the FEIR.
And I believe that was the point.
That could be the point he's making, but what he is doing now is providing a further critique of AMM 20 that could have been provided at any time in Part 2, and I'm happy to rest on that. And then I'd also like to add another housekeeping matter for consideration for the daily schedule, the schedule for today. I'm also prepared today to lodge some two short objections to Dr. Paulson's testimony. If we'd like to conclude that up today, I'm not sure. I guess it may be that Mr. Emmerich does have to come back, but I did want to offer that while I'm here today as well.
All right. Mr. Herrick.
John Herrick for South Delta Party. Sorry to bother you. I had a conversation with DWR's counsel earlier. Their understanding was that only they would be able to cross the DWR witnesses, Dr. Chimilcurry and Mr. Bernardsky, rather than everybody else could cross. There are a number of people here that were expecting to cross those witnesses too. I just wonder if we get a clarification on that.
Who's they? You said you talked to DWR and...
I think it's that CCLP would be limited to cross.
Correct.
Is DWR's position.
Correct.
Other people can't cross.
Well, I guess we'll discuss it now. I was going to discuss it later. Now,
We can do it after lunch
Hold
if
on.
you want.
Well, yeah, let me just remind everyone that allowing CCLP to continue this line of inquiry was a special accommodation we made to Ms. Womack to ensure that CCLP's due process rights were preserved. So the focus of Dr. Chimakuri and Mr. Bernardsky's testimony was solely on CCLP's water rights and impact to CCLP's water right. I believe that then would focus the cross-examination to that, only that conducted by CCLP, because it is their water rights that is at stake. Now, if other parties wish to offer a proof as to their standing with respect to this matter, what your property interest is in CCLP's very specific water rights, you may try to make that demonstration. But otherwise, cross-examination of Mr. Bernardsky and Dr. Chimakuri would be limited to CCLP and anyone else who can demonstrate to us that they have a property interest that is relevant to cross-examination about CCLP's site-specific water rights.
John Herrick again. I'm not sure I could make a property right. My point is only that when Dr. Chimakuri discusses water quality analyses in the South Delta, that we have an interest in challenging or examining those conclusions and the locations of the conclusions.
No, that
But-
analysis by Dr. Chimakuri, again, is specific only to the extent that it impacts CCLP's water rights. Everyone else has had the chance and plenty of opportunity, and you did conduct cross-examination of these witnesses. We brought them back specifically to accommodate Ms. Womack and only Ms. Womack, and Mr. Moore, I'm sorry, with respect to potential impacts to their water rights.
Good afternoon. Yes, the way I understood it, and that's why we're discussing it now, is that in particular, Mr. Bednarski's testimony provides a long list of ways in which the water rights of CCLP would be addressed by DWR. And I believe that does raise concerns by other legal users of water who are participating in Part 2 to the extent there's changes, as we've discussed before, and there's some representation. So that's of interest to all diverters within the Delta if there's representations as to what kinds of mitigation would be offered to CCLP and whether, how those would work and whether those would apply to other diversions in the Delta. So I guess, I'm asking that I think we could ask our questions to be specific, obviously, to the testimony, but I think that there is some room for questions that are direct, that as much as CCLP has similar interests as other water users in the Delta that may have their diversions disturbed by these activities, it seems that those questions should be able to be asked as well, because this is new and different testimony and information.
As specific to CCLP.
It is.
Ms. Desjardins is up next.
The way I understand it, it's not, especially with the water quality effects, they're using information that is broader geographically.
Yes, and that information everyone has had opportunity to examine and cross on. Again, we brought them back specifically to address CCLP's issue.
This is Deirdre Desjardins with California Water Research. The direct testimony which is being presented is not presented as answers to CCLP's questions. It goes significantly beyond the
Then
specific
Mr.
scope.
Emmerich will have the opportunity to conduct his cross, but to the extent that it goes beyond CCLP's specific issues, Mr. Emmerich, I think, will be quite in his right to bring up those issues and make any objection he or Ms. Womack deem appropriate.
And the other issue I would have is that this is new information. It is direct testimony. The original September 10th ruling was that they would bring these witnesses back for cross-examination. It was then clarified that direct testimony would be presented. This direct testimony provides new information
Specific,
that was not in
specific
the testimony.
to CCLP and CCLP's water rights.
To the extent
To the extent that you can demonstrate a property interest in CCLP's water rights, you may try to do so now.
then I would like to move for the consideration that any information in consideration that any information that is provided in this direct testimony or in cross-examination be used by the board solely for the consideration of CCLP's water rights and not for any other consideration in the petition, because cross-examination by any other parties is being denied.
All right, Mr. Emmerich, do you have anything to add before I move on?
I think what Ms. Desjardins just stated should be, I think, our understanding as well, is that if there isn't going to be additional cross-examination, that the information would be only used with respect to CCLP's water rights.
That was my understanding. Anything you wish to add, Mr. Mizell, since we're talking about your witnesses?
The only piece of information I would add is that the testimony of Mr. Mendarsky with regards to the mitigation measures does nothing to modify any of the mitigation measures previously set forth in our testimony for any other water rights user. So I believe I'm in agreement or at least alignment with the rationale you've just explained as to how to delineate between what we're going to hear today and what we've heard before, and assert that it has not changed any of the information that other parties have had the opportunity to cross-examine.
All right, thank you, Mr. Mizell. With that, then I think we're all of the same understanding with respect to Mr. Bernardsky and Dr. Shumakuri's testimony and cross-examination by CCLP this afternoon. If there are still no other cross-examination planned for Mr. Worth, then I will overrule Ms. Ainsley's objection and ask Mr. Worth to present his direct. Upon then, we may excuse him and take our lunch break.
I'd like to take my dad to lunch. So what time is the break over?
Mr. Worth, will you be wrapping up in around, say, 12:30? All right, then please be back at 1:30.
Thank you so much.
Anywhere you want. Good afternoon, Mr. Worth. I always welcome people back, but in your special case, I especially mean it. Welcome back.
Appreciate that. It was a bit of a challenge to get this together, and I stayed up until about 3 o'clock in the morning putting these pictures together.
Oh, no.
So it was with a little bit of effort.
All right. Thank you for accommodating Mr. Worth. This testimony is presented on behalf of Save Our Sandhill Cranes. And Mr. Worth, is SOSC 85 a true and correct copy of your written testimony?
Yes, it is.
And do you have any corrections to that testimony?
I do. Page 2, line 27, same should be some, an O instead of an A after S. On page 9, line 22, SOSC 19 should be SOSC 16.
Then I think we'll want to go ahead and pull up that PowerPoint if you could, Mr. Long. It's SOSC 86, I believe. And then, Mr. Worth, in preparing for your testimony, did you read portions of the administrative draft supplemental environmental impact report, as well as the 2018 CER and the other materials cited in your testimony?
I did.
And then once your PowerPoint comes up, if you could please summarize that testimony.
So that's a very close-up picture of a sandhill crane's head. And what many people don't realize is that the red there is not the color of the feather, it's the color of the skin. So I was tempted after putting that picture up to call my presentation instead of the surrebuttal testimony, "The Emperor Still Has No Clothes." But I felt that would be inappropriate, so I stuck with something more official. For the purpose of this testimony, I would like to use the word final for all references to the final EIR, EIS, and use the word supplemental for all references to the administrative draft supplemental. It'll make it go faster and less tongue-tying. Second slide, please. So my testimony states that the supplemental fails to address substantial changes in the project footprint, and it relies very, very heavily on the contested final. Legally contested throughout the entire testimony of people regarding the crane. And I want to draw people's attention to the second bullet point. It's just a reminder of what we're dealing with here. It's a no-take species. Next slide, please. Relying on a flawed and legally challenged final for concluding that the supplemental is adequate is akin to a house of cards. The reasoning is a type of circular logic. The justification used for a new conclusion are as flawed or more flawed than the original conclusions that it is based upon. But claims are made repeatedly that the original conclusions now support the new conclusions, which I found to be very problematic. Next slide, please. So using the example of the greater sandhill crane and its treatment in the final and the supplemental will illustrate my difficulties in this particular claim. So AMM 20 is a flawed underpinning for the supplemental for sandhill cranes. The first element of that AMM 20, the first measure, is a measure about noise and disturbance avoidance and minimization, and it relates to timing. And it's supposed to minimize construction during the crane wintering season, but only if it's practicable in the light of project schedule and logistical considerations. Next slide, please. So the exhaustive qualifiers and the non-binding language of this measure make it aspirational at best, and as a result, it provides very little help for dealing with the new impacts identified for the greater sandhill crane in the supplemental. That's a little meadowlark singing on a post. Next slide, please. Looking at the second measure in AMM 20, we see equally problematic language. There is already construction planned, as we see from the conceptual engineering, what's the exact name? The conceptual engineering schedule, actual conceptual construction schedule. Looking into that, we already see there is planned winter construction in areas where cranes are currently extant. There's no actual requirement in this second measure that no new disturbance occur when cranes are here unless it is feasible. So once again, we are left with non-binding language that is aspirational at best. Next slide, please. So basically, these first two measures are duds. There's nothing in these measures that provides any assurance that the impacts described in the final were adequately addressed. And similarly, there's no assurance that they will be addressed in the supplemental. Next slide, please. So moving on in the AMMs to the AMMs for the greater sandhill crane foraging. The first measure here is also to the extent practicable, and it relies on water conveyance facility final design to minimize pile driving and general construction-related loss of greater sandhill crane habitat. Next slide, please. But it appears that project components felt that it was not practicable to minimize a loss of foraging when the northern shaft was moved south in the supplemental, and this results in significant issues with sight lines for foraging and roosting cranes. And the enormous scale of that shaft and its design, essentially, creates these problems and these serious issues for sight lines. We're one slide behind. We need to go one slide forward. Okay. Next one, please. The next measure dealt with noise. There's a little comment there. Wasn't there supposed to be no noise anyway because no construction was supposed to occur in the crane season? That's not the case. Noise is supposed to be limited from 1 hour after sunrise to 1 hour before sunset. Actually, 1 hour after sunrise, 1 hour before sunset. And the visual effects of these noise barriers on sandhill cranes are unknown according to that measure. So all other options to reduce noise will be implemented before installing noise barriers in close proximity to crane habitat. Next slide, please. The greater sandhill crane is a no-take species. There would likely need to be an extraordinary amount of noise barriers to avoid take from birds flushing off their forage sites due to construction-related disturbances and hitting a power line during construction during the winter. Next slide, please. So MM20 is flawed in its individual measures and as well as a package of measures. Considering the MMs discussed thus far, we see that there is no enforceable requirement to avoid construction during the crane wintering season. Construction is already planned during the crane wintering season. There's no enforceable requirement to complete construction projects before or start new construction during the crane wintering season. We also see the water conveyance facility design for both the intake near the Stone Lakes roosting complex and the new placement of the northern shaft on Staten Island indicate that it was not practicable to avoid and minimize impacts to cranes by way of project design. Pile driving general construction noise is required to be limited near crane wintering areas at night for noise exceeding 50 decibels, but no existing measure for foraging, sorry. And the experimental use of noise barriers will be used as a last option. Next slide, please. So it brings up the question, are sound barriers our only available solution? So we see winter construction is planned, and it's going to occur when the cranes are here. Daytime noise limitations aren't there. It's only nighttime noise limitations, so it's going to be a definite impact on foraging. There's a correction there too for the blue one. There should be only one to do instead of two. The noise barriers will have to do the heavy lifting of dealing with the construction disturbances and these noise activities. The measure for having enhanced foraging opportunities hopefully will keep the cranes in the wintering ground away from the loudest sounds. But essentially the only thing on offer with the flexible language of the other measures is these noise barriers. Next slide, please. So Staten Island is an example of what using these sound barriers would look like, and the like should be look. Not like, but look like. For noise and general disturbance from construction, the Staten Island Performance Standard is basically the same as the design for conveyance facilities measure, which includes the sound barriers. Next slide, please. Is it possible to zoom in on the Staten Island part of that? That would be about the lower third. Keep going down. Maybe it's not. There you go. I was somewhat shocked when I saw this picture. It's the first rendering that I was aware of for the noise contours for Staten Island. You can see how extensive they are. I tried to cut them out and move them around to see how much of an impact that was on the landscape, and it appeared to me to be about a third of the island, which is substantial. But presumably, they're going to be using these sound barriers to minimize this sound. Next slide, please. But the problem with that is that, I'll wait till it shrinks down, is that the impact of these sound barriers on the sight lines and visibility issues for cranes aren't known. So presumably they're going to stay some distance away from these sound barriers. There's no analysis to indicate how far that might be. And quite possibly, the amount of land not usable in Staten Island will be the same as if there were no sound barriers there at all. They would stay as far away from those barriers as the sound would be issues. So that's very concerning, and it was not addressed at all, and there was no analysis whatsoever for the changes on Staten Island, either for the northern shaft or for the changes in the safe work harbor areas. Next slide, please. This is a reminder that no take is the bar here. It's a very high bar. It's an absolute. And this issue with the sound barriers brings up an interesting philosophical point because it illustrates the paradoxical nature of using noise barriers for a no-take species. Because the inherent risk of flushing birds due to construction-related disturbance, it would make a lot of sense to use lots of these barriers to minimize those impacts on the birds. No noise, no disturbance, no flushing, they don't fly away. But if you use a huge number of these barriers, you create new problems. You have roadways lined with these things, construction sites lined with them. You're limiting the sight line availability for these birds and increasing the potential they might fly into them when the visibility is poor. So if you do as much as possible, you create a problem. If you go halfway, you haven't done enough to protect a no-take species. So it creates really a very substantial catch-22. Next slide, please. The only way to avoid these construction impacts to cranes would be just simply to say there is no construction during the wintering season. This is an absolute no take. The only way you can absolutely do that is to completely avoid it, not using flexible language. The sheer scale of the project and the no-take status of these 3 avian species creates a very difficult and problematic absolute. The unenforceability of the AMM 20 and the plan to do winter construction in the crane wintering area essentially guarantees there's going to be take unless there's no winter construction. Next slide, please. For the northernmost shaft on Staten Island, there's going to be no work whatsoever on the shaft or in any of the safe haven work areas for the entirety of the crane wintering season. Next slide, please. Too bad I can't get that a bit lighter. You can hardly see the detail in that photo. For Bolden Island, the muck storage and related disturbances are way up in the supplemental. And Bolden is right next door to Staten Island. It's literally the next island to the south. Cranes have been recorded on Bolden Island for decades. Cranes that live on Staten Island, the central stronghold for a sandhill crane population in our area, easily goes there and forages. It's well within the 2-mile zone. So relying on MM20 and the final to claim that new impacts are adequately addressed despite the supplemental failing to analyze the extent of these new impacts, it's just purely inadequate at all. There should have been specific analysis addressing the new muck footprint, the new noise from the muck footprint, the effect on the statin birds, et cetera, and not just relying upon MM20. For lesser sandhill cranes, this is a species that uses a much larger part of the landscape. Its home range is about 10 times that of the greater sandhill crane. And the theory, which is basically true, that what is good for the greater sandhill crane is good for lesser sandhill crane is accurate. But it ignores the fact that this bird using a large amount of the landscape is more likely to have impacts on that larger landscape. There's no discussion of that at all. And in conclusion, the supplemental is flawed. It falls short in explicating the full impacts from the substantial changes that it covers, and its reliance on a contested and flawed document to explain why it does not need to provide any additional analysis of the substantial new impacts runs completely counter to the public trust. AMM 20 falls short of avoiding and minimizing the impacts to greater sandhill cranes. The only guaranteed way to assure that the impacts of this species from activities contemplated in the supplemental and the final are fully avoided and minimized would be the condition that no construction-related disturbances occur for the greater sandhill crane in its wintering area in the winter. As things stand now, the project will result in completely unacceptable impacts to local and protected wildlife. Thank you.
Thank you, Mr. Worth. That concludes your
Yes,
direct,
that does. Yes, so I would ask.
Hold on, let me, I see Ms. Ainsley rushing to the microphone. Nope. Okay. Shall we let Ms. Meserve proceed? Or do you have an objection to voice?
This is more of a, I believe it's really more of a housekeeping matter. I believe that Ms. Meserve is going to move SOSC 88 into the record, which is a paper by Gary Ivey et al. I believe this is already in the record as SOSC 17. So I just wanted to note that these are duplicative exhibits.
Ms. Meserve, can you confirm or deny?
At this moment, no. If it is indeed a duplicate, then I don't wish to confuse the record.
We will note that.
So,
but at this time?
Yes, at this time, I will go ahead and move them all in with the caveat that if 88 is the same as 17, then we don't need to move that one in. So that's exhibits SOSC 85 through 90.
All right.
It is the same, I just checked it.
Oh, it is?
It is the same?
Yep.
All right.
All right, so we will take out 88 then.
Thank you, Ms. Ainsley, for pointing that out. The exhibits are received into the record. Thank you, Ms. Meserve, and thank you, Mr. Worth.
Thank you.
Mr. Keeling.
Thank you. Tom Keeling for the San Joaquin County Protestants. This makes sense, except when we're reviewing his testimony, if there isn't some notation in the revised testimony replacing the one exhibit number with another, everybody will be completely confused and we'll have to do a whole new search through all the exhibits to find out what was referred to.
Good point, Mr. Keeling.
I could submit a revised and just correct that one.
How many places are there in his testimony is that citation made? And if so, why don't we just make it on the record right now?
I believe it was with Bolden.
It should be searchable.
Which page do you see it on?
Actually, I don't think it's referenced at all, is what I'm being told now. I just did a quick search. I don't see it being cited in his testimony.
But it's an incorrect site. There were a number of SOSC sites that were incorrect, but since it had the name of the article in brackets, I kind of went with it. That there's also an SOSC 86 is actually SOSC 88. SOSC 87 on lines 3 to 4, I think is already been corrected. That might be 89. So I just think that that's the article we're all referring to.
Well, in that case, since there are multiple corrections of citation, Ms. Meserve, I will take you up on that offer to submit an errata.
Yes, I will do so.
Thank you. All right, with that, we will take a lunch break, and if anyone see Ms. Womack and Mr. Moore, please tell them we are now returning at 1:40. right, good afternoon, everyone. We are back, and before we turn to cross-examination by DWR and state water contractor, I don't see Ms. Meserve in the room, but Mr. Emmerich, let me check with you. When you confer regarding Dr. Paulson's testimony on behalf of Antioch, I had land down as being requesting 10 minutes for cross-examination of Dr. Paulson. Did you confer with Ms. Meserve as well before we say that Dr. Paulson do not need to appear? Well, I think Ms. Meserve was in. Microphone.
I think Ms. Meserve was in the audience when that was raised by
And she
Ms.
didn't
Morris,
object?
and she did not object.
Okay, I just want to make sure we,
Firm, but I don't think that there was an objection.
all right. And I don't see Ms. Ainsley here. I believe she said she wanted to voice some objections with respect to Antioch testimony, so we'll get back to that when she's back in the room. So for now, I will turn it over to Mr. Mizell and Ms. Morris. What is your time estimate for cross?
I think we're going to stick with 40 minutes.
40 minutes? And you will stick, I assume, to basically the organization that's in the testimony, or is there any particular, in terms of outlining your cross?
We're going to, yes, stick to the organization of the testimony. We won't be jumping around very much at all. In fact, looking at the page numbers, it's in sequential order.
Sequential order. All right. Thank you.
Okay. Mr. Long, if we could bring up CCLP 60, please. And if we can go to page 4 when you get that up. And on page 4, if we scroll down to line 21, please. So this first line of questioning is going to be focusing on the statement about halfway through line 21 that says, thus CCLP had no reason to question CWF facilities.
Mr. Mizell, for some reason, I don't think it's just now, I'm having trouble hearing you today. And so, more importantly, so is the court reporter. So if I might ask you to perhaps bring the microphone closer and maybe slow down a little bit?
Sure.
Thank you.
So I'm focusing on line 21, about halfway through the line, the statement, thus CCLP had no reason to question CWF facilities and operations. Question is, so Ms. Womack, you were allowed by the hearing officers to submit any questions you have about impacts to the CCLP diversion point, is that correct?
I'm not sure what you're saying. When was I allowed?
You were allowed in writing by the hearing officers to submit any questions you had of DWR about the changes described in the SEIR and the diversion point you have on the Jones intake channel. Is that correct?
I submitted questions on August 9th. Some questions I had.
So is that a yes?
I don't know what else I've done this SIR rebuttal. I did the August 9th questions. What else have I done? And I've done my my testimony. Yeah, no, but the rebuttal was on the SEIR, I think. Yeah. I was just trying to think of all the things I've done. Sorry.
So you were afforded the opportunity to submit questions in writing to DWR?
Yes, but they were not answered. The ones on August 9th were not answered.
Thank you. And the hearing officers ordered DWR to produce witnesses and testimony for the purposes of answering your questions.
My August 9th questions is what I've been told.
Is that a yes?
This is what my understanding is. And, well, actually, also, no, I've been told that that I was given, no, I was given that what
think I've gotten
is
an
being
answer to my
presented.
question.
Hold on. Only one of you may speak at a time, or the court reporter will walk out,
right.
and this will end. Not to
Great.
give you any ideas for today. Okay, Mr. Mizell, your next question.
DWR witnesses have yet to testify in response to the board's order that they appear to answer questions, correct?
Well, yeah, they have submitted their testimony.
All right, that's not my question. My question is, they have yet to testify at this point in time, correct?
Yes.
Thank you.
Mr. Mizell, do you have more question along this line?
I have one more.
Okay, because I'm about to ask what is the purpose of this, but go ahead, ask your question.
So you'll have the opportunity to question DWR witnesses about the California WaterFix facilities and operations with a scope that encompasses both parts 1 and 2 of this hearing. Is that correct?
I have the questions that I've submitted to them that I hope to get answers to. I don't know what those answers will be.
Okay, thank you. If we could go to page 6, please. And looking at lines 16 through 18. Here the statement reads, CCLP believes that any obstruction of the DMC intake will injure CCLP's senior riparian year-round licensed contracted water right. My question is, what do you mean by any obstruction?
Well, I was referring to what Mr. Chilmacurry I had referenced before about the modeling I was referring to is the DSM-2 model, and it does include the intake in general, but not the specificity. We need to analyze Ms. Womack's diversion. So when I said CCLP believes that any obstruction of the DMC intake will injure our CCLP senior riparian year-round licensed contracted water rights, I was referring to the control structure, but at this point I didn't know which side the control structure was on, because I think before this last testimony it was on the control structure was after we had our intake, and then it was the control structure. So Tracy Fish Facility, control structure, our intake is what I was given when I wrote this.
So if I understand you correctly, you are referring to when you refer to obstruction, you mean either the control structure or the Tracy Fish Facility or your diversion point itself.
Oh, well, there's other obstruction. The other, I don't know, would that be an obstruction, the other control structures? There's other things that are going to influence the DMC intake. So I don't know if that's an obstruction or not.
When you say obstruction, are you referring to those other things that you just alluded to?
Any obstruction, yeah.
What do you mean by obstruction?
Obstruction, all of the structures you want to put in the DMC intake and the things that connect to it. Anything is going to change.
So any structure.
Whether it's the channel that you have the south tunnel outlet structure, you have the channel from it, you have a control structure between that and the other. You have all the operations, and they're you know, the dual, the BTO, you have many different operations that depend on these different obstructions that will be added.
So you believe that operations are an obstruction?
I think they can be. They can change, and that they can change my water level.
You're not referring to physical obstructions?
Oh, I'm referring to both. Because there are physical ones that are going to then change things. The control structure right by me is the biggest example.
All right.
Mr. Mizell, since I am also unclear about this, let me try asking it this way. Ms. Womack, if we were to consider a condition to alleviate what you believe to be the impact described here, what would that condition look like? How would you phrase it? In terms of addressing this obstruction that you cited, what would be the mitigation for that?
I honestly,
If you know, you can answer. I think one of the problems is, of course, that, you know, the analysis of how the control structure, water levels, hasn't really been performed. We don't know what that's going to be.
So I'm sorry, is her concern then, when she say obstruction of the intake, is it relating to the water level?
It's relating to anything that's going, right now.
Anything that might interfere with
our diversion.
your
Right
diversion.
now, I have nothing, and somewhere in there it says the no action alternative is the same as a control structure.
That's fine. I just wanted to try to understand.
Nothing versus whatever they throw in there is going to obstruct in some way in our ability to take water.
Thank you.
Do you know if the Jones pumping plant intake channel is a man-made waterway?
I know that the upper portion by our ranch is Herdland Canal that was actually put in when there was the flood in 1907 by our property owners. So I know that it is, that part is. My dad would probably know about the other part of the DMC intake.
Okay, that's it. Yeah. Well,
The DMC intake, ours is man-made, the Herdland part.
no, it was the old, they went down the Herdland Canal.
They went down our Herdland Canal.
No, but
The rest
thing
of
is,
it-
my big problem here is with the whole thing. They're taking up to 20,000
I'm sorry, that's
second
not.
feet out of
Let's
the-
stop, please. Stop,
Okay.
please.
We need to, he just wanted to know about the canal.
Yes, the
Yeah,
question,
that's a big
Mr. Mizell,
problem.
was,
Yes.
Whether or not it was man-made?
So it was, our part, the part up to the Byron Highway was part of a control that was made, a canal that was made, I believe, in 1907 by Herdland people,
Thank you.
and then taken over eventually by the CVP.
Thank you. The water right that you claim in this sentence, is it for agricultural purposes?
We have year-round water rights. You would have to look at the license. Is it just ag?
We have riparian rights going into the 1880s and.
We have riparian, yeah.
License.
Dad, he wants to know, are they
don't have
ag
the license.
rights? We
What?
don't have the license with us.
I don't have the license with us. do
Yeah,
you?
you would probably know that.
License.
We don't have it, I don't have it with me today. As far as, I know it's a year-round. I know it's senior to 1880s, 70s. And I know I also have a contract with Department of the Interior. And I have a license, 1925 license.
Okay. Does CCLP or its tenant farmers utilize planting practices and timeframes that are common for the South Delta region?
I don't know what's common for the South Delta region. They use year-round water rights.
When you refer to a contracted water right, what do you mean?
I'm referring to the 1955 land purchase contract where an exception was made for our water because they purchased the farm's floodgate, and they had to move it. So as you read the contract, and I'm sure you have, it says that they're moving this riparian right in the DMC. It's a very unusual situation because it was a floodgate. It's cost us so much to.
And Ms. Womack, the contract was with?
Department of the Interior Reclamation, signed in 1955 when they purchased for the Tracy fish, I don't think it was, for the fish screen.
What exhibit it is?
Yes, it is exhibit, let's see, that's CCLP 62, and that's along with the 2000 letter that Department of Interior sent when they provided this contract. I believe we had it, but it wasn't in such pristine order. So, yeah, this was regarding CalFed when they wanted to purchase our property.
In the 1955 land purchase contract does not guarantee a specific quantity of water to be delivered to your diversion point by the CVP or the SWP. Is that correct?
No, you're wrong.
How much water does it guarantee to be delivered by either the CVP or SWP?
Well, we'll have to look at that contract. Could you pull it up, please? And you'll have to realize this contract was made when our farm was 1,157 acres.
So this is CCLP 62.
Okay,
Where would
so
you
we're going to
direct
have to
us?
go down to about page 7 or 8. This is on page 3 of the contract. So let's see, page 3 of the contract. There we go, where the little arrow is. Let's see. The United States agrees to transport and convey through riparian, appropriative, or prescriptive waters, provided, however, shall not exceed the rate of 1 cubic foot per second continuous flow to each 80 acres of irrigated land formerly irrigated through the facilities located at said point of diversion number 2. So this is, you have to go back quite a ways to realize this was part of 1,157 acres. With the way the land was taken, most of this property is now irrigated by this diversion.
Isn't it correct that this sentence that you just read and is indicated on the screen with the arrow in CCLP 62, page 3 of the 1955 contract, isn't it true this is a right to transport and convey water and not a water right?
Oh, well, it is, I'm sorry, it speaks of our water right on page 2, I believe. At the very bottom, there's a paragraph. There shall be reserved to vendor, his heirs, executors, administrators, and assigns any riparian or other water rights or water rights now.
Ms. Womack, you need to slow down.
Oh, I'm so sorry. It's on page 2 of this contract, so one page up. So it's it's a little paragraph. But I believe it's talking about our water rights because this is all to do with taking our water rights.
Right. The sentence on page 3, if we could go back to page 3 where the arrow is, reads that it agrees to transport and convey through the canal to your pump water at a rate of 1 CFS. Is that a correct reading of this?
I would think you need to read the entire contract, but that is one part of the contract, yes.
And so the language that you pointed to when I asked you if you had a contract with the CVP to deliver you a specific quantity of water does not actually guarantee you a quantity of water from the CVP or SWP, only a right to transport water.
Transport and convey our water. I'm sorry, I believe this is a land contract and with the ability to give us water.
And as you just said, it was to transport your water, correct?
It is taking it, what they've done is they've removed it from the river and they've placed it in the DMC. This is the same water right that we had at the river. It's a floodgate.
Clue what you're talking about.
I don't know.
Hold on. Ms. Missouri?
I'd like to object to this line of questioning. It calls for a legal conclusion from Ms. Womack, and I don't believe that she's qualified to answer that.
Ms. Womack has asserted that her water rights is being impacted. I need to understand what she means by that. And I believe that's the line of questioning, so overrule Ms. Missouri.
Right. But this is part of this contract, that they are going to be putting our right in there. This is part of this purchase agreement. I don't know why the Department of Interior would want to not, why would you have this in the purchase agreement?
That's going beyond the scope of the question.
Okay.
So,
Let me see if I can.
please.
I am not a legal water expert on this contract, but this says contract.
Let me ask you, let me see if I can help clarify the record here. I only promised to try, so hopefully everyone will be very patient. Does this contract provide you SWP or CVP permitted water rights, or is it simply a contract to transport your existing water rights?
It is, since there was no SWP in 1955, it can't be SWP rights. CVP rights are saying that they will take it to this point. This is the point they've agreed upon. I don't know what that becomes.
You are asserting that you have a contract for CVP delivered water under their water rights.
They will deliver to this point, is what they say.
And the basis of the contract is not, let's be clear, we're not talking about delivered. I'm not talking about the delivery. I'm talking about what's the basis of the water that's being delivered. So is it your assertion that they are delivering your water rights or CVP water rights? That's the question.
Yeah, they are my riparian water rights. Yes.
Okay, so this contract doesn't give you a right to CVP water, rather it's a conveyance agreement to convey your existing water rights, correct?
Yeah.
Okay.
I believe so. But I think yeah, okay. We'll leave it at that. As far as I know, I may have to come back and say something different because I am not a contract lawyer, but this is the contract that I have.
If we can go to page 8 of CCLP 60, please. And on page 8, looking at lines 15 to 17. Am I reading this correctly to say that you believe removing tidal influence will cost CCLP money?
Yes.
That's the general statement?
Yes.
Hypothetically, if the water in your channel at your diversion point were artificially made higher, so tidal influence was removed and it was made higher, wouldn't that result in you saving money?
Dad, do you want to explain pumping? You don't say.
I don't know. Here's the thing.
You don't say, there's a certain point of pumping where it's an even point. When you put it higher, you don't save more. When you drop lower, it's really expensive. It can double the amount of expense. But when it goes higher, you don't pay less. And as an engineer, I'm sure you understand that. But
You know, we're sitting here.
Hold on, I'm sorry. Hold on. We can't hear Mr. Moore.
they don't. Yeah.
You don't understand.
No, they don't, Dad.
At the 20,000 second feet coming out of that river affects us. It has affected us from the day one, it affects us today, right now. And you go in and
Hold
bring
on,
all this
hold on.
superficial stuff in, it's just baloney.
That is not
We gotta
responsive.
stop. Okay.
Mr. Mizell, do you wish to explore this further, or do you wish to move on?
I'd like to ask one question in response to Ms. Womack's answer. You indicated there was a point, water level elevation, where it neither cost you money nor saved you money. That anything at that point or higher didn't actually save you any money. What's that water elevation?
I wouldn't know. I'm not a farmer. My dad would know.
Mr. Moore, what's the water level elevation that...
Water level? What's water level?
No, what is the water level elevation at which...
Mean sea level?
No.
You want it mean sea level? What do you want it in?
Hearing Officer Dudek, I withdraw the question.
What
Thank
reference
you.
do you want? What reference do you want?
I withdrew
Hold
the
on.
question, Mr. Moore.
Question.
Oh, okay. All right.
Ms. Womack, isn't it true that DWR disputes that it owns the pumps and pipes installed for CCLP drainage that you've identified in your testimony at pages 10 and 11?
I've only been told this recently, in the last couple, I was very surprised with council saying that they don't own it. Dad, regarding they're very interested in the discharge pipes coming from our property, going onto the DWR property and into the Clifton Court forebay. Could you explain how you had to set that up over 50 years ago? Because
Hold
that's
on.
the only thing I can go with.
Hold on. The question was, to your knowledge, has the department dispute the ownership?
Never until this last, there's been no dispute.
Right.
Yeah. Until
recently.
Until a year ago when we got a crazy letter.
Thank you. That answers your question, Mr. Mizell.
Mm-hmm. So I'd like to bring up CCLP 40, please. Ms. Womack, in this letter, the department grants you a temporary entry permit to repair your drainage system. Is that correct?
Could we refer to the top of this paper first? There is no letterhead. This is a letter from someone. If this letter is in response to our meeting on June 27, 2017. If you go down to the person that signed this, I have never met this person. I have never had a meeting. I don't know what else to say.
So you are disputing the authentication, the authenticity of this?
I'm offended. I got a TEP order.
Hold on.
So this is actually an exhibit that was submitted by, this is a CCLP exhibit that they
Yes.
submitted.
Correct.
Yes,
So
to show the incompetence.
I don't think there was a question.
Are you,
Oh, sorry.
I'm trying to
Mr.
understand.
Mizell, are you stipulating, or are you hereby authenticating this letter as being from the department? Because her purpose in submitting it was to question its authenticity. So you can't, you're now going to ask her a question about a document to which she questions the validity.
I'm having a hard time understanding why she's questioning the authenticity of her own exhibit. But if we go to CCLP 32,
We're going back to CCLP 62?
32,
32.
Yes? 32. And here is a scanned image submitted by Ms. Womack from the state of California, Department of Water Resources. And if we scroll to the next page, the person signing this letter, again, is Ms. Amber Candela Cooney, the same signatory to the other letter.
All right.
Again, this is not written on letterhead. Again, I submitted this to kind of show this is what I'm dealing with. This is where she claims I don't have a seepage problem because SEEP 6 works.
All right, all right. So let's get to a question, Mr. Mizell.
So I'll restate the previous question. Looking at CCLP 40, isn't it true the department granted a temporary entry permit to CCLP to repair their drainage system, your drainage system?
DWR DFD sent me a letter with a TEP asking me to repair their drainage pipes. My father is sitting here. If you would like to ask him about drainage pipes, I would suggest you ask him because he was there when they were installed. This would be a perfect time to get this on the record and get this cleared because the fact that DWR's memory does not go back 50 years is alarming.
I move to strike that last response as non-responsive.
So noted. Is there a question pending, Mr. Mizell?
Looking at the top of this letter, Ms. Womack, it says, in response to our meeting on June 27th, is your contention that you did not meet with anybody from DWR?
No one from CCLP met. When I received this letter, I was shocked.
Right.
We immediately wrote a letter in
all right.
response.
So
Isn't it true that you have a tenant farmer?
I have a tenant farmer, yes. I'm a landowner with a tenant farmer.
And are you aware that your tenant farmer regularly coordinates with DWR Field Staff Division?
You know what? What he does is entirely his own work, but that would be like asking a renter things about my rental property. I'm the owner. This is who you should deal with.
That's not my question, and I'm sorry, but I'm just trying to be precise here so we can move on. Is it possible that your tenant farmer met with DWR?
I have no idea, but this is not, they said CCLP, which should be the people. We're the landowners.
Did you ask your tenant farmer if he's ever had any meetings with DWR?
Why would I do that? I'm
asking you the question.
Hold on.
Have you or have you not asked your tenant farmer if he's had meetings with DWR?
Have I asked if you've had meetings? I may have asked, certainly. They live next door. I don't recall at this point.
So your testimony is that you are unaware of your tenant farmer ever having any meetings with the Department of Water Resources?
No, I didn't say that. I just don't know. My tenant farmer has 2,500 acres. We're 500. We're 1/5. We don't have a lot of time.
All right.
I'm a landowner.
All right.
Okay, I want to go back
Water rights.
to, I don't think there's an answer, but I'm going to go back to CCLP 32. And is it your contention, Ms. Womack, that you never called anybody at the Department of Water Resources on or before February 14th, 2017, regarding an issue of 25 acres on your property?
We have had many, I have years of letters. They're regarding all sorts of problems. This was that year. This was to do with seepage. This was to do with 6-inch seepage.
So the question, though, is whether or not you recall if you made a phone call and discussed this issue on or before February 2014, 2017 regarding this issue?
Oh, I absolutely called and asked about seepage.
And do you remember who you spoke to?
I spoke to several people to get there. I may have spoke with Amber at some point. I spoke with several people, though, because that was when every month there was a new director after my dear friend Diana retired. This was a period when it took several weeks to get the right person.
Do you recall writing a letter on April 11th, 2017 to Director Croyle?
I've written many letters, yes.
So you do recall writing about this same issue, about the 25 acres, to Director Croyle?
This is happening during the floods of 2017. When the forebay is closed.
I really am not trying to
I'm not
be rude
either.
or cut you off, but I'm trying to ask questions, and it's really important for the record that your answers be in response.
But nothing is black and white.
I understand nothing is black or white, but some of these questions
Ms.
are
Morris,
about records.
Ms. Morris, please just ask the questions.
I'm trying. So let me go back and ask again. Do you recall sending an April 11th, 2017 letter to Bill Croyle, director at the time for Department of Water Resources?
Yes, can we see that letter?
25 acres.
This was at that point, yes. I was very concerned.
And isn't it true that on May 26, 2017, as you've marked CCLP 63, that the Department of Water Resources looked into the landowner seepage concerns?
Yes, they did. It should be noted that okay.
Hold on.
Sorry.
If there's any further clarification you need to provide, Mr. Emmerich will do that on redirect. Ms. Desjardins.
Yes, the hearing officers have stricken Ms. Womack's testimony on seepage.
Oh.
And there is very detailed cross-examination about letters on seepage and response. This is specifically referring to a letter that was not admitted as an exhibit because it was ruled as beyond the scope. The seepage has been ruled beyond the scope. And to allow questions by Ms. Morris on seepage, there has to be a consistent ruling on scope for this not to be arbitrary. And if she is allowed to ask questions on seepage, then to not be arbitrary, I would like to be able to ask follow-up questions. These are issues which we tried to explore and the adequacy of DWR's response, and it was ruled beyond the scope.
Ms. Morris, you may respond.
I'm not intending to ask questions about the seepage issue, but rather the understanding of the communications and the back and forth, and that's what I'm trying to explore.
Thank you. That's my understanding. Objection overruled. Proceed to your next question, please.
Because this is what they said not to allow. I couldn't talk on this.
If we could bring up CCLP 63, please.
I wasn't allowed to do that. This is what I wasn't allowed to present.
The purpose here, aside, Ms. Womack, aside from the very specific seepage discussion, you have introduced evidence that, in your opinion, attests to the lack of communication between yourself and the department, and that is what they are exploring. Not the specific issue, but the communication chain.
Okay, so it won't be about anything to do with seepage or the desiccation or anything that I was not allowed to bring in. Yes? Okay.
They are only pursuing the communication and demonstrating, at least I think they're trying to demonstrate that there was communication back and forth with
Absolutely.
you.
So just for my clarification, this was previously stricken and not allowed into evidence.
Just to make things easier, I'm going to withdraw the question about CCLP 63. We will do it through a different document.
Okay.
Oh, well, yeah. Oh, I missed that, huh? And that they haven't done anything with it.
Could we bring up CCLP 60, please? Oh, 60. Sorry, not CCLP 60. DWR 936. Yes, 936. So, Ms. Womack, is this a Superior Court judgment?
My father can answer these questions. Yeah.
Looks like, appears,
Speak into this.
yeah, it appears to be so.
And in the defendant's portion of the caption, Mr. Moore, is your name in the defendant's portion of that caption?
Certainly involved in that because I had a lifetime lease on the property.
Ms. Woback, if you could please pull the microphone to Mr. Moore? No, pull the microphone to him.
You know, I will say this, I had it says, let's see, I'm named on there. And
Thank you.
I had a lifetime lease on the property.
Okay. If we can move to page 4, please. Focusing your attention on lines 7 through 11, does this portion of the settlement state that you have been paid for any and all damages to your property suffered by reason of the construction of Clifton Court 4-Bay?
It never happened.
Are you claiming this judgment never happened?
Never happened.
This judgment never happened.
You said we weren't made whole.
Yeah.
Never.
This was.
If we
this was
scroll to the
not-
bottom of page 5, please. Is this judgment signed by Superior Court judge and dated December 15th, 1970?
That's what it says there.
So would you like to revise your statement that this judgment never happened?
I would make the statement that it was never fully carried out. It was partially carried out, but not fully.
If we could go to page 8, please. And scrolling down to this until you find the list of 4 signatures on the left. Mr. Moore, is your signature found on this page?
Yes.
So So based upon this document, isn't it true that CCLP has already been compensated for any injuries that you may claim due to the construction of Clifton Court 4
What?
No, they were never.
I'm going to object that it calls for a legal conclusion. Obviously, what you've shown in this document does not go to to negligent maintenance. It doesn't go to omissions. It doesn't go to negligent operations. It only goes to the construction of the 4 bay.
I believe that's an objection, so I'm waiting for a ruling.
What was your question again?
Whether or not this document, isn't it true that CCLP has already been compensated for any injuries that you may claim due to the construction of Clifton Court 4 bay?
I believe he's answered that several times, that in his opinion, they have not been.
Yeah, CCLP has not been. My grandfather was compensated. That's
Mr. Mizell, there's a difference between
not completely.
Hold on. About asking him what his understanding is versus what his legal interpretation of this document is. He has answered it in terms of what he understands, so we'll have to leave it as that.
That's very good. Isn't it true that DWR and CCLP have been engaged in negotiations for the purchase of your land prior to the most recent SEIR?
We've had negotiations with the CVP under CalFed. We were asked to a meeting with Sergio Valles and a few other people. There were no DWR people there that I know of. So no, we've engaged in zero. There's been nothing.
You've never engaged in conversations with DWR
Conversations?
as to the purchase of CCLP?
2004? No. No, I mean, we had CalFed. We were almost ready to sell with CalFed. Then the bombings happened and the market fell and there was no money. And so CalFed went away. That was the last time we were in any sort of things. You are a DWR person.
Isn't it true, Ms. Womack, that DWR had discussions with you recently regarding WaterFix and the purchase of your property and in fact made you an offer?
No.
And so your testimony is also that you didn't counter offer on that?
No.
So you've had your testimony?
We met in 2012, I believe, with Sergio Valles. I don't believe he's DWR.
All right, it has been asked and answered, and your 40 minutes is up. Is there much more you need to ask?
No, we'll conclude our cross-examination.
Thank you.
Goodness.
I believe Lan and DDJ, Ms. Desjardins, have also requested cross. I'll leave it to you to determine who goes next.
I have a little thing at home. It's from,
All right.
but nobody made an offer.
Ms. Desjardins requested 10 minutes for cross.
Yes, and I'm hoping it will take less than that. I'd like to pull up Exhibit CCLP 62, please. Page 7. And please scroll down to where it's highlighted. Ms. Womack, so it's this contract states, the United States agrees to transport and convey through said canal to the pump constructed by vendors, said vendors riparian appropriate over prescriptive waters. Said canal to the pump constructed by vendor, said vendor's riparian appropriative or prescriptive waters. Has Reclamation ever discussed with you providing water conveyed from the North Delta intakes when that supply might be blocked?
No, we've had, CVP have not met with us at all regarding our water and what will happen to it with this California water fix. We've had no conversations. Of course, I get things in writing, and we've had no writing either.
Have they ever had any discussions or offered to amend this contract to provide a substitute water supply?
Absolutely not.
Has DWR ever offered to amend this contract, to provide you a contract, to provide you a supply of SWP?
Absolutely not.
And I'd like to go to was it Exhibit DWR 963, please? Was that?
I think it's 936. It's the judgment, that one. Yeah.
Yeah, sorry. 930, DWR 936.
Yes.
And I wanted to ask your dad, when you were negotiating the terms of this contract, of the terms, the settlement terms for this judgment, hadn't DWR obtained some of your property through some kind of action? Or yeah.
I don't frankly understand.
Okay. Yeah. Were you under extreme stress when you negotiated the terms of this contract?
My father was not involved in any negotiations. My grandfather was a great negotiator, and my father was the tenant farmer.
Okay, thank you.
He did not have any rights to negotiate.
That concludes my questions.
Thank you. Ms. Meserve? Mr. Emmerich, any redirect?
Take just a second.
Well, but this keeps coming up. Let's get that in the record. Oh, if you can.
Yes, so.
On what issue?
This is going to be on the May 2017 meeting at the property.
Okay.
Well, you
There was no meeting.
You didn't have a meeting?
No.
But somebody came, DWR visited the property in May of 2017, is that correct?
Are we recording this? Is this? Yes, Mr. Emmerich is not testifying, so.
I'm asking the question.
You're asking a question. So hold on. So your request for redirect is to clarify whether there was a meeting on?
In May, yes. There was not. I had sent a letter to Director Coyle, and I would imagine at some point in May, there was an engineering report, which is CCLP 63.
And that was stricken, but there was an investigation that was performed by DWR in May of 2017 of the seepage. Is that correct?
Eventually, I found that out. I didn't find this out until January of 2018.
All right, stop right there.
Okay.
Mr. Mizell? Nope.
I'm just prepared in case we go further.
Continue, please.
And there was, your understanding was that a report was prepared as a result of that investigation. Is that correct?
Yes, I should clarify too,
When did you get that report?
I received the report in January of 2018.
And did that report suggest certain remediations of the property?
Now there's going to be a, Mr. Mizell?
Yes, I'd like to object is going beyond the scope of our cross-examination.
Sustain.
But you did not receive the report until January of 2018?
Yes.
Okay, that's all I have. Thank you.
Thank you. Any recross? All right. At this time, I believe you have exhibits to move, and I believe, Mr. Mizell, you had indicated earlier you had objections to exhibits. Shall we hear your objections first, Mr. Mizell?
But he's going to object first, yeah.
And actually, before you begin, how lengthy are these objections?
I believe that many of them you will be able to deal with today. They are objections that are being put onto the record simply for completeness, but based upon our discussions this morning, I expect the answer to be quite obvious to us all.
Well, we shall see. Proceed, please.
Okay. Let me get my copy of the testimony. Please hold on. So I'd like to raise an objection to CCLP 61. It is referenced within Mr. Moore's statement of qualifications, but it deals with seepage. So I'm raising the objection of out of scope, recognizing, however, that you overruled the motion to strike this morning.
And so you are...
So for the record, I would just like to know if we will be admitting CCLP 61 over an objection of out of scope. Essentially, I just need to confirm this morning's rulings as they affect these exhibits. So if we are leaving it in the testimony, I would expect my objection to be overruled.
Your objection is overruled.
Okay. I have an objection to CCLP 63. 64. 63 and 64 is being beyond the scope dealing with seepage. Those are within the struck testimony.
That would be 64, correct?
And CCLP 63. CCLP 63 is referenced page 9, line 20. And 64 is page 9, line 22.
All right. They are so removed.
We don't get to do anything. That's the... Well, it's not seepage. It's to do with a failure. It's damn failure. But CCLP...
It's in the section that was struck this morning.
Well, but it's damn failure. He's saying it's the
It's
wall's
in the
failing.
section that was struck this morning.
Wow, okay.
And then we're objecting to CCLP 65 through 68. They're referenced in the testimony on page 11 with regards to the conversations, the letter exchanges between DWR and CCLP. We're, again, objecting to those as discussing existing facilities and outside the scope.
And overruled.
I do appreciate your patience. This is just something I have to do for the record.
It's a lawyer thing, isn't it?
It is. We like to be annoying sometimes.
Is that all, Mr. Mizell?
Similarly, we object to CCLP 62. This is within Mr. Moore's statement of qualifications. We believe it's outside the scope.
Similarly, it is overruled.
CCLP 69, again, within Mr. Moore's statement of qualifications, we believe it's outside the scope.
Overruled.
And then the reference to CCLP 40 found in the testimony, CCLP 40 was previously ruled beyond the scope of Part 2 in a June 18th, 2018 ruling. For Mr. Derringer's purposes, that's on page 2 of that ruling. In that ruling, you indicated that CCLP 40 does not relate to the WaterFix project or any Part 2 key hearing issues. So we would object to that exhibit as being beyond the scope.
I'm sorry, where in CCLP 60 is that reference?
Page 11.
This was introduced for the purpose of the communication argument that Ms. Womack
Yes.
made. So the objection is overruled.
Thank you very much, and thank you for your patience.
So what does that leave us with, Mr. Emmerich? I hope you were keeping track.
I think we're just missing 62, 63 and 64. So we would like, well, go ahead. We'd like to move into evidence everything except CCLP 63 and 64. So 60, 61, 62, 65, 66, 67, 68, and 69. And my my testimony is 60. Okay, and my testimony. I don't know these things.
Thank you. Those have been received. Thank you, Mr. Moore. Thank you, Mr. Womack.
Thank you for your time.
That's okay.
And thank you, Mr. Emmerich.
Yes. Thank you, Mr. Emmerich.
Let us take a short break, and we will do a musical chair and ask Mr. Bednarski and Dr. Chimakuri to come up. We will return at 2:50.
Okay.
55.
You're out of here. Yeah, I'm staying, but you're going. I have to stay. Yeah.
Test 1, 2, 3, test 1, 2, 3.
It's 2:55, we're back. Before we turn to DWR's witnesses, Ms. Ainsley, Mr. Emmerich, Ms. Ainsley had previously said she had some objections with respect to Dr. Paulson's testimony. And let me confirm with Ms. Meserve, now that she's back, that although you requested time to cross-examine Dr. Paulson, you do not object to the agreement reached between Antioch and petitioners to not require Dr. Paulson to appear. Thank you. So stated for the record. Now, Ms. Ainsley, your objections.
Yes, my objections for the record are, it's my understanding of the September 10th, 2018 ruling that the hearing officers discouraged repetitive rebuttal evidence that provides no new evidence. And it is my objection that opinions 1 and 2 of Dr. Paulson's rebuttal testimony, which is Antioch 700, are wholly repetitive of the testimony provided in Antioch's case in chief, Antioch 500 errata, and in their part 2 rebuttal, Antioch 600. While she does purport to be responding to Dr. Chilmacurry's testimony, what she is doing in opinions 1 and 2 is merely re-summarizing her conclusions from Antioch 500 and Antioch 600 using the same charts from Antioch 600 and expressly referencing that that's what she's doing, in fact. Aside from her repetition of her earlier testimony, she provides no new evidence or different rebuttal to the testimony of Dr. Chilmacurry that was not already laid out. I am not extending this objection to her third opinion, just to make sure that's clear for the record. I am talking only about opinions 1 and 2 of Dr. Paulson's testimony, Antioch 700, and I'm happy to give page sites. I pulled it up. That would be starting on page, I believe it's page 3, line 2, with the title Opinion 1, going through page 8, line 24.
Response, Mr. Emmerich.
Well, my response is, first thing I want to ask is this in addition to Ms. Morris's objections, or is this a separate objection?
I don't believe Ms. Morris had any objection.
She told me she would have an objection to Dr. Paulson's
I
that she
believe
was going to
that-
bring up on Monday.
I apologize for interrupting you. I believe that what she was doing is reserving my right to make objections over the phone, which she knew that I had. We coordinate, and so I have the objections for Dr. Paulson here.
So these will be objections on behalf of DWR and state water contractors.
That's correct.
So my second statement would be that I don't have that testimony in front of me. I just,
You were focused today on other matters.
if I could reply to that objection Monday morning.
I'm happy to provide the testimony on my computer too. If you would like to show up Monday morning, that's fine.
Let's do this, since Dr. Paulson is not appearing in any case, regardless of our ruling on this matter. Do you need Ms. Ainsley to submit her objection in writing?
If she could just send me an email, that'd be fantastic.
Actually, we'll have to send everybody the email, but please do that, Ms. Ainsley, by, well, I don't know what time we'll finish today, so how about by noon on Monday? Unless you can do it today.
I can see if I can sit here and craft something, and we'll see if it can be served for us. I'm not one of the people who
You know
does
what,
the
let's
service.
just, have you submitted by noon on Monday, Mr. Emmerich? You may have until noon on Tuesday to respond.
Thank you very much.
Right.
We are not going to have further proceedings on Monday?
I don't know yet.
Okay.
It
Thank you.
depends on how today goes.
Thank you.
In any case, we also have Mr. Burke still left to hear from. All right, I think that takes care of matters for now. And before I forget, though, if we do reconvene next week, I believe there's been a change in location. Yes, instead of Bayou Share, we'll be in the coastal hearing room. All right. I just wanted to get that out before I forget. Now we'll turn to Ms. Ainsley and Mr. Mizell.
Thank you. So in response to your ruling to have DWR produce witnesses and testimony in response to questions about CCLP's water right, We have produced Mr. John Minarski and Dr. Chandra Chamakuri. They have both appeared before you in earlier portions of this hearing and have sworn in those proceedings. So I won't ask them to rise at this time, but simply attest to the rebuttal testimony, and then I'll turn the microphone over to them, as is our practice. Mr. Bendarski, is DWR 1417 a true and correct copy of your rebuttal testimony?
Yes, it is.
And Dr. Chamakuri, is DWR 1421 a true and correct copy of your rebuttal testimony?
Yes, it is.
Thank you. So we will start with Mr. Bendarski, and after he has completed his summary, we will turn it over to Dr. Chamakuri. Mr. Bendarski.
Thank you. I'm going to take a few minutes to summarize my testimony of DWR 1417. Can we go to DWR 1305, sheet 55 of 96? I'd like to take just a couple minutes to review the facilities in the South Delta that are now included as part of the California WaterFix with the supplemental EIR, EIS, and the July 2018 CER.
Let's wait until we get it up.
Yes, absolutely.
So that's DWR 1305, what page?
Sheet 55 of 96. No. It should be down in the bottom right, the sheet numbering. I don't have the PDF page number. There we go. Okay. In front of us here is an overview of the facilities at the south end of the California WaterFix facilities. Starting at the upper left, we have the two main tunnels. We'll be entering into the Byron Tract forebay, basically shown as that trapezoidal shape there, triangular shape. At that location, there are two pump stations. Each 4,500 CFS will lift the water into the Byron Tract forebay. There's a range of water surface operating elevations that will be established during preliminary and final design to set the final hydraulic gradient available coming out of the Byron Tract forebay. Water will then flow through a series of gates at the south end of the Byron Tract forebay by gravity into the two south tunnels, each one about 1.5 miles long. The water will then well up in the connection channel that's shown in yellow here, that is on the south side of Byron Highway. At this point, the water from the North Delta diversions can flow either to the Jones intake channel, or the DMC as others call it, or it can also flow to the Banks intake channel. With the facilities that we are providing here, there are 4 control structures that allow us to operate in 3 different modes of operation. And those control structures on this drawing are labeled as control structure number 1, which is on the intake to the Banks plant, that yellow square. We also have control structure number 2 that's located on the Jones intake channel and is shown as a yellow square over there. It's the one that's been the subject of our discussions here today. And then inside that yellow connection channel, there are also 2 control structures there. Control structure 3, which leads into the Banks intake channel, and control structure number 4 that allows water to flow into the Jones intake channel. With these 4 control structures, we're able to operate in 3 different types of modes of operation. The first is North Delta diversions only, and under that mode of operation, control structures 1 and 2 gates will be fully open, and control structure number 3 and 4, those gates will be closed. And water will flow, much as it does today, into the Jones and the Banks plants with those gates fully open. It will be our goal to design a structure, a gated structure, that minimizes the amount of head loss or energy loss through each of those structures. And the reason for this is that we have relatively tight operating windows of water surface elevations at both of those pumping plants, and we want to maintain those current operating conditions into the future. The second mode of operation, I'm sorry, that mode of operation that I just described is the South Delta diversions. The second mode of operation would be for the North Delta diversions. And under this mode of operation, the gates in control structure 1 and 2 would be closed, and the gates at control structures 3 and 4 would be opened. And these gates are what we call throttling gates. The water will flow from the Byron Track forebay well up in what we call the South Tunnel's outlet structure. And these two control structures will modulate to regulate the amount of flow going over to the Jones intake channel and the Banks intake channel. As I mentioned earlier, gates or control structures 1 and 2 will be closed, so there'll be no water from the South Delta entering. The third mode of operation then is what we call dual operation, where water from both the North Delta diversions and the South Delta diversions will be blended. Under this mode of operation, as we currently envision this, with our conceptual engineering completed to date, control structure 1 and 2 gates will be opened, and then the gates at control structures 3 and 4 will be modulated to allow a blend then of water from the north and the south diversions to occur in both the Jones intake channel and the Banks intake channel. So that is kind of a brief description of the three modes of operation. Based on our analysis to date, it is my opinion that there will be no impacts to the Clifton Court LP water rights, either from the footprint of the control structure number 2 or from our intended diversions under any of these 3 operating modes. We still have quite a bit of work.
I'm sorry, Mr.
Yes.
Bednarski, let me stop you right there. Mr. Emmerich?
Oh, I'm sorry, I didn't see where any of that preceding testimony was in his written testimony.
Mr. Bednarski?
I believe that's covered in the conceptual engineering report.
Is it in your testimony, however?
The description of the operations? I did not go into a detailed description of that, but I have referenced the conceptual engineering report, I believe, in my testimony.
And a discussion of the operations can be found on page 3, section 1B.
Let me locate it. I'm sorry, where is it, Mr. Mizell?
Page 3, section 1B. The little b at the top of page 3, beginning on line 4, proceeding to line 15.
I see it. All right,
Proceed?
proceed.
Okay. So we've completed conceptual engineering for the California WaterFix facilities. The upcoming engineering activities will include detailed hydraulic modeling of the entire California WaterFix hydraulic facilities, starting at both the Jones and the Banks plant and working our way back up to the Three River intakes. This information and modeling will be used to develop and refine the system hydraulics that will then allow us to proceed with preliminary and final design of the control structures and all of the facilities that have been highlighted at the south end of the California WaterFix. If impact.
John, please.
Yes.
We have another
I
objection.
did have an objection to the statement, we have completed conceptual engineering for the WaterFix facilities. I did not see that in Mr. Bednarski's written testimony, and it goes considerably beyond the scope of impacts to CCLP's water rights.
The conceptual engineering reports have already been put into the record as exhibits from DWR. Those reports weren't disputed at that time. To the extent that Ms. Desjardins believes that they may be modified in the future. I don't think that's what Mr. Bendarski is testifying to, and maybe he can clarify. But his references to conceptual engineering reports are to the exhibits that are already in the record.
And let's narrow it down, Mr. Bernardsky. Your reference is as they pertain to potential impacts to CCLP.
Yes.
Let's keep in mind, I think you were here when we had this discussion before our lunch break, that the very narrow scope of your testimony is CCLP and CCLP's water rights.
Thank you.
So your comments and testimony will be taken into that narrow focus.
Very good. During the preliminary and final design, if impacts to Clifton Court LP's water rights are identified, my testimony commits DWR to implementing mitigation measures to reduce or eliminate those potential impacts, and those have all been outlined in my testimony. Temporary and permanent impacts will be addressed, even if those are identified after startup of the WaterFix facilities. It's completion of my summary.
Good afternoon. Before I start, I have one minor typo that I'd like to correct for the record. On page 10 of my testimony, Mr. Long, if you can please bring up DWR 1421. On page 10 of my testimony, line 24, where it says this sentence that's starting figure 3 is based on, it should say figure 5. I'll give a brief overview of my written testimony here. My testimony is primarily to conclude that the operations of the control structure within the Jones intake channel will not diminish the availability or the conditions of water to at CCLP's diversion location. Mr. Long, could you please bring up figure 1 on page 2 of my testimony? Thank you. As Mr. Bernardsky just described the operation or potential operations of how the water will move through the between the Byron Tract 4 Bay, which would be the water that's coming from North Delta diversions into the that would be the new source of water that would be pumped from Banks and Jones pumping plants, and there's water moving from South Delta channels directly through Clifton Court 4 Bay and Jones intake channel. I just want to...
Hold on a second, please. Ms. Womack.
I was wondering where on the maps that figure is from that shows the exact location.
You may ask that during your cross-examination.
Oh, sorry about that. I just was
Please
wondering.
proceed, Dr. Chimakuri.
So I think in order to understand the water availability and the conditions, it is this figure is going to help us understand the location of Clifton Court LP's diversion location in reference to Old River and the proposed changes in the DMC intake channel. So as you can see there, the big blue box identifies the area where that's expected to be affected during construction. That's the footprint of the control structure that's being proposed. And the red circle indicates the CCLP's diversion location. And I just show with arrows where which direction is Old River Channel and which direction Jones Pumping Plant is, just to help us orient. You can see that the proposed control structure would go in between the CCLP diversion intake and the Old River, which are right now tidally connected, as Ms. Womack was testifying earlier today. And the new Byron Tract 4-bay water, the South Canal, which brings in water from the Byron Tract 4-bay to the Jones Pumping Plant, that goes in between CCLP's diversion point and Jones Pumping Plant. So that, having that in mind, is important to understand what kind of water will be going past CCLP's diversion intake. So as Mr. Bernardsky just testified, there are 3 modes of operations that are possible. One is water, just like today's conditions, water would be directly diverted out of South Delta, and there won't be any supply coming from the North Delta diversions. In those conditions, the control structure gates would be open, and the CCLP's diversion intake will have similar conditions as the Old River Channel, because those are tidally connected. They will continue to be tidally connected even after the control structure is built. So I expect that the water levels and the water quality would be similar to the Old River Channel conditions near the junction of the Jones Intake Channel and the Old River. And we'll get to what those conditions would be like in a minute. The other 2 operation modes that we talked about is either there is a blending operation or an isolated operation where the water is coming from North Delta diversions alone. In those situations, the water quality at CCLP's intake, I expect it to be better than today's conditions, because there will be if it is a blended operation, then the South Delta water will be mixing with the water coming from the Sacramento River, which is much fresher in terms of salinity. So you would expect that the salinity and the blended salinity would be lower there. And I have results that I will show you in a minute here, what I expect those results to be. And if there is no blending and if the control structure is closed, then the supply we expect the water supply that we expect at CCLP's diversion intake will be of Sacramento River water quality, which would be much better than what they are currently getting today from the South Delta channels. Mr. Long, could you please bring up figure 2 in my testimony, please? While that's happening, previously in this hearing, you have heard from Dr. Nader Tairani, Dr. Smith, or Ms. Smith, and myself explaining to you that the South Delta salinity conditions with WaterFix are expected to be similar to the no-action alternative. We have provided extensive testimony to that effect. What I did here in figure 2 is, again, demonstrating to you the same point that in the Old River Channel, this is right near where the Jones Intake Channel intersects with the Old River. So I would expect this water quality at CCLP's intake as well, if the control structure is open and there is no flow coming from the Byron Tract 4-bay. So this would be an existing operation, essentially. As shown in this figure, obviously I'm presenting a long-term average here, but you can see that the salinity conditions are fairly similar. There is a slightly higher EC under the CWFH3 plus compared to the no action. However, if you may recall, I believe in part 1 of this proceedings, Dr. Nader Tairani explained that increase is primarily due to the head of Old River Gate operations and that affecting the salinities in the South Delta channels. So based on this figure, I expect that under that mode of operation, when the water going into Jones Pumping Plant is only originating from South Delta channels, the salinities would be similar to the no action alternative at CCLP's intake. Mr. Long, if you can please bring up figure 4, please. Figure 4, number 4, page 9. Oh, yeah, thank you. So again, in continuing forward with the same mode of operation where the diversions are only from the South Delta channels, this figure is showing the water levels in the Old River at the junction of the Old River and the Jones intake channel. And I expect the water levels at CCLP's intake would be similar to the water levels in the Old River as well, because they are tightly connected. And what you see here is that I'm plotting the daily minimum water levels that are modeled using DSM-2. And the red line here is the CWFHT+, and blue is no action alternative. And as you can see, across the 82-year period, the water levels are very similar to no action, or in fact, very slightly higher actually than no action alternative. And in this mode of operation, I expect that the CCLP to continue to see similar water levels as no action alternative. Mr. Long, could you please go to figure 5? I think it's last page. Thank you. Figure 5 here shows the blended water quality, or blended EC at Jones pumping plant. So if the mode of operation is going to be, there's going to be water diverted from both South Delta channels and also from the Byron Tract 4 Bay, the expected water quality in the Jones intake channel, and by extension at CCLP's intake, is that the CWFHT+ would actually result in much better salinity conditions than the no action alternative. So I'd expect that under all modes of operations, CCLP should see better water quality conditions than no action alternative. And there was a lot of discussion about my responses previously about there's no modeling present to help understand what CCLP might face. I just want to address that a little bit, and I did summarize it in my testimony to that effect. We use, all the results I'm presenting here are based on DSM-2 modeling, just to be clear. And as I said in my previous testimony, that the DSM-2 model does not have the control structure we are talking about explicitly represented in it. However, it reflects the operations of that control structure. And it is explained, the way the DSM-2 boundary conditions are set up is explained in the DWR 1142 Appendix 5A, which is the biological assessment. And it explains how the different mode of operations are considered in developing those boundary conditions. So if you, for instance, I'll just give you one quick example. If the control structure is going to be closed, that means the water supply will come only from the North Delta diversion. In that case, the boundary condition in DSM-2 model at the Jones pumping plant for the export value will be set to 0. And you can check that, but that's how it is represented in the model. And I've provided references to DSM-2 input files in my testimony, just to be clear about that. And if there is pumping from the South Delta channels, then there is a value for that time series, for that boundary condition. So that's how we represented it in the model, even though the structure itself is not explicitly present. With that, I conclude my summary.
Thank you. Mr. Emmerich and Ms. Womack, if you could please come up.
For our DSM modeling, I'd like to ask Deidre Desjardins to help out with some of the modeling, as she's much more familiar. Thank you.
So Hearing Officer Dodek, if I might ask for some clarification, Ms. Desjardins is providing technical support. Is that what was just discussed?
That is my understanding.
But the questions will be coming from Mr. Emmerich, the attorney for CCLP.
They will be coming mostly from Ms. Womack, but they will secondarily be coming from me.
Okay, thank you.
As long as they are focused on CCLP's water rights, then it's within the scope. Do you have a time estimate for a cross?
4 hours?
Probably an hour each. I think we'll start with Mr. Bernardsky. Ms. Womack will take the lead. I will ask some follow-up, and then we will move on.
I will remind all of you that it is our typical process to provide for 1 hour of cross and then additional time upon an offer of proof. So we will start with the 1 hour.
All right. Mr. Bernardsky, did anyone help you with your testimony?
DWR's legal staff assisted me in formatting it to its present format.
I appreciate that. Let's see. Who do you work for?
My employer is the Metropolitan Water District of Southern California.
And are you the section manager of the Water Supply Initiative? That's what it's, is that your title?
Yes, I am. Yes, that's my title.
Okay. Are you the program manager for the CWF?
I'm going to raise an objection here, or maybe a clarification. We've been informed that they have 2 hours of questions they would like to ask. To the extent that we've been over Mr. Bendarsky's background in many sections of cross-examination before, if we could simply go to the substantive questions, we might be able to better streamline this rather than have a fight later about whether or not the first hour was used effectively.
I agree.
Do you have authority to make legally binding decisions for reclamation?
Objection calls for a legal conclusion.
He does or he doesn't.
Yeah, I don't know how my authority pertains to Bureau of Reclamation. I believe that my testimony commits DWR to my statements in my testimony, though.
So do you have authority for commitments from Reclamation then?
It's been answered.
No. Okay. Okay. So. Do you have a letter confirming, do you have a signed letter from DWR confirming your legally binding authority?
Objection, again, calls for a legal conclusion, but as the department's attorney, I can assert that any commitments that Mr. Bendarsky has made to mitigation have been assessed at the department, and we would commit to those if they became terms and conditions of our permit.
So noted, sustain.
Okay. So the control structure on page 2 of your testimony, 1417, Mr. Long, if you could put that up. This is qualified at the bottom as an aerial photo, clearly shows CCLP intake structure. Is this in the CER or SEIR EIS?
Yes, that's a blow-up of an image from the CER.
Do you have a reference for that? Because it says it's an aerial photo.
Yes, I do. Can we go to DWR 1305, sheet 55 of 96? It's the same one we looked at previously. There we go. Now, if we can magnify that area for the control structure that's in the DMC. Yeah, it's on the scan to the right side of the image.
So it's from this is
there you
the
go.
reference.
Okay, now that yellow box there, I believe if we continue to magnify that, we should be able to see keep going. Oops.
This is where you got the structure from.
I'm sorry?
This is where you got this photo from. This isn't an aerial photo, or this, I'm just looking for the reference number for this photo, because I don't see that being the same as what you show.
Objection asked and answered.
No, we created this image for my testimony based on the footprint that's shown right here using the exact same coordinates that are shown on this drawing. We do not have this figure in the CER. We created it specifically for this testimony to show the relation of the CCLP diversion in regards to the proposed control structure.
Okay. Have there been any surveys of that?
We have not done any surveys. We have gone off of GPS coordinates.
Which are not included in this picture. But not in the picture on page 2. I don't see any coordinates.
No, we didn't include those coordinates on.
I would say that this is not, this does not provide a legal.
You may make that argument in your briefs. Right now, you are cross-examining these witnesses.
Okay. Yep. Okay. So next, on page 2 of your testimony, you conclude there's no impacts to CCLP from the construction. And what you say here is that it is the sole basis for this, appears the sole basis for this opinion is that the distance between the construction impact of the control structure and our diversion is 100 feet, is what I've read. That is on page 2, lines 26, starts on 25. So based on the conceptual engineering, the clearance between that.
And your question is?
Excuse me. So the question is that the sole basis of your opinion?
Objection misstates the testimony in the preface to that question where she said the sole basis was 100 feet. Reading his testimony exactly, he says the construction footprint is more than 100 feet.
All right, we will make a note of that. And Mr. Bernardsky, answer the question, please.
I'm sorry, could you repeat the question?
Probably not.
Is the sole basis your assertion about distance?
So is the sole basis for your assertion there is no, there's no impact of the control structure? Is it just based on distance?
No, I think that this statement was related only to whether from the temporary construction impact or the permanent footprint would not disrupt the existing diversion. This statement is not based upon any conclusions about operations of the system. This figure was only used to demonstrate that the footprint, both temporary impacts and permanent impacts, did not fall on top of the existing diversion that is about 100 feet downstream of that location.
Okay.
That was the only purpose for that statement there.
Okay. You say that the 14.8 construction structure is part of the approved plan. It is a 2.2 approved plan structure. Is this your best rendering of the 14.8 project acreage and how it will look and what will?
Objection.
Well, again,
Hold on.
Trip.
It's a question's vague and ambiguous. There are a number of numbers in there that
The
did
original
not read very concisely. If we can get the question restated so that we understand exactly what statement you're referring to.
The original structure was 2.2 acres. It says here that it's in the approved plan that it's 14.8. I guess I'd like to know, I'd like a rendering of what is going on in this whole acreage of 14.8.
Okay, if we go to page...
I'm not clear on what the question is.
Oh.
If you see the blue box, there's a blue box that shows 14.8 acres, and they say there's not going to be
That's what I've been, is that correct? The blue box is the 14.8 acres?
Yes, if you go to the footnote on page 4, I believe it explains what all three of those
Okay.
different.
So then, Ms. Womack, your question?
What else is going to be on here? I've been told there's some, you see, there, in one of the questions, in one of the responses that was
I can't refer to that response because we struck it.
Okay.
So
well, okay, so what else will be on here, on this structure? We have the control structure in the center, and supposedly that's not going, what else is going to be on this?
The permanent footprint of the structure is shown in red. Okay, that's approximately 4.6 acres, and I believe that's what we've cleared through the environmental process as far as a permanent footprint for the structure. As we're doing our construction activities, we're going to need a staging and mobilization area. We may also need to construct a bypass of the canal around the construction area. So we've set aside the area shown in blue for those temporary construction impacts.
Okay.
Those areas will be regraded back to their pre-existing, configuration once construction is complete. So those are considered temporary impacts as opposed to what falls within the red rectangle, which is a permanent footprint for the structure.
So during construction, will you have, the blue will be, could you put that down, Mr. Long, just a little? Well, the blue will be, it will be completely gated off. Is that what I'm led to believe when you do the construction?
It's yet to be determined whether it would be gated off. If there are access requirements for, say, patrolling the aqueduct levees or perhaps accessing the CCLP diversion, then those would have to remain open during construction. So, as we get farther into the design process and understand the different constraints for usage of the levees and access to different points, those would be made available and not blocked off.
So it will 24-hour access during construction.
Well, we'll need to figure that out as we get into the process, whether 24-hour access is required and whether our work is blocking some area that needs 24-hour access. If that's required, then that will be provided.
My contract, 1955 contract? Okay. Can you commit to any specific access at this time?
no, he cannot.
No, you can't. Was that a no?
I believe at this point, we would provide access to your diversion point, perhaps through some temporary access roads. We'd have to get into those details. I couldn't say right now, but, it doesn't seem infeasible to me that we couldn't provide you that access at that location.
I have to provide huge cranes to replace my pump, my 1955 design pump.
And what's the question?
So will I have a commitment that I can reach that at any time?
Objection, vague and ambiguous as to what direction should he be approaching, what time of day.
It's the shortest route.
And the shortest route, based on the picture, does not have any obstructions between it and the road.
Are you able to provide any commitment at this time, Mr. Bernardsky?
I believe that we could provide CCLP access if required, with some notice if we were otherwise blocking their access. Otherwise, some continuous temporary access that would be outside of our construction footprint could be looked at as we get into preliminary and final design. It's not our intention to impede their access to that point.
Okay. Can you commit that the blue line of construction will not be changed?
No, I cannot do that at this point. We have completed conceptual design. We still have preliminary and final design, but this is our best estimate at this point in time as to the temporary construction footprint.
Okay.
I think it's still up for debate. I believe our property is 15 feet on the other side of the road between the Herdland Road and Canal, but we can split nails later. I'll take it that you're working on that. Let's see. Let's see. So in your testimony, you say that in your testimony, where is the 127-acre new South Tunnel outlet control structure that you showed, but you don't talk about in your testimony?
Can we go back to DWR 1305, sheet 55 of 96? I guess we're on that sheet already. Now we are. Keep scanning down in the way you're going. Right there, stop right there. That is it where you see that kind of like figure 8 circles? I believe that's the structure that you're referring to.
Yes, it's not in your construction potential impacts. Why not?
I'm not
being ambiguous as to what piece of paper she's looking at, what exact construction impacts. Are you holding his testimony? Are you holding?
I am, let's pull up, let's see, 1305 PDF 84 would have it. I want to know that why this structure isn't considered as part of your testimony.
Which structure?
The South Tunnel outlet structure.
And just for clarity, DWR 1305 is a volume of the CER?
CER, PDF 84.
I'm going to object to facts not in evidence and beyond the scope. Ms. Womack has not laid any foundation that this structure's footprint would be on her property and therefore have any impacts to her water right. We were looking at property south of Byron Road.
So Ms. Womack, what is this that we're looking at?
Well, this is the South Tunnel control structure that all the water from the tunnels will be coming into, and then I believe, I'm not sure, this is going to be sorting the water. The water will come up in it. I don't know if SCADA will be housed here. I don't know how this 127-acre addition, if you go to the next page, Mr. Long, 85, this shows this. This is 127 acres. That structure is, well, you can see where it's labeled, South Tunnel Outlet Structure. And it goes into the DMC outlet intake.
And your question is?
And my question is, how is that going to affect my diversion?
To the best of my knowledge, that structure should have no impact on your diversion.
So it has nothing to do with the amount of water, or does it house SCADA? Where is SCADA housed?
We haven't determined the location for the SCADA system. We'll probably have it distributed through different computer modules at each of the control structures, and then there will be devices at that outlet structure that you noted. Where that data is collected and processed, I don't have an answer for you right now.
The outlet structure I noted, which, you mean the South Tunnel?
Yes, it's a South Tunnel outlet structure, that's called out?
Yeah, just like the DMC intake, yeah. So, but that is going to be, that will have data there as well?
I believe there'll be equipment there that will collect data. It may process data at that point. I do not know at this point where DWR plans to set up their main control facility for the California WaterFix facilities, but that data would be relayed to that location. And then operators at that location could take actions remotely to operate the gates in either that structure or in the 2 control structures that are in that channel, as well as the control structure that is shown in the bank's intake channel there off to the left, and then also the one that's in the DMC.
Is there any way CCLP can communicate with the operators with the control structures, the various ones, so that if our water levels are impacted?
I assume that you would have some sort of a communication protocol with the field operations group or with DWR operations in general. I don't have an answer to that at this point.
Are you willing to commit to that?
Objection. There's been no foundation laid that Mr. Bednarski is going to be an operator.
Well, he is
the California
our expert.
WaterFix. He's the construction expert here. He's testified to where he thinks the SCADA may be located, which is yet to be determined. And frankly, it would be my objection that the location of the SCADA system or data processing is irrelevant to the issue of who in the field operations Ms. Womack would be regularly dealing with that may not even be different from the past. So I think any further questioning on this line would be beyond the scope of Mr. Bednarski's testimony.
Yes, you bring up a good point. Mr. Bernardsky, according to your CV, your work
So that was an agreement, sustain, all right.
So, yeah. According to your CV, you have work has included reconfiguring the river intakes, the tunnels, and pumping systems to achieve budget, schedule, and environmental commitment for the program. I'm taking this from your CV. Where is your construction expertise?
My object is to relevance. Challenging Mr. Bendarski's CV at this point is not productive.
Sustain.
Yeah. Okay. All right. All right. So let's see. I haven't asked any of those. Yeah. Asked them? Mm-hmm. Okay. So what about CCLP's other water diversions? Where do you analyze the potential operational impacts from the new Byron Track 4-bay, the tunnel configuration, and the pumping plants on CCLP's other diversions?
Objection.
Other diversion. What other diversion? You need to be more specific, Ms. Womack.
Oh, well, we have a total of 3 diversions.
So be specific.
The diversion in front of the Tracy Fish facility.
Can you locate it on a map? That objection vague and ambiguous until we have a location provided by Ms. Womack in any of her testimony as to her other diversion points. Mr. Bendarski isn't, at this point, prepared to answer those questions. There has been absolutely no foundation laid that Ms. Womack has other diversion points that are impacted in ways other than what Mr. Bendarski has explained here.
All right, sustain, Ms. Womack.
Let me ask a follow-up, maybe a clarifying question to Mr. Bednarski. Are you aware of any other diversions that CCLP has to take water for use on its property?
No, I'm not.
Only the one that is located in what we were calling the DMC?
That's correct.
And when did you first become aware of the location of CCLP's diversion within the DMC?
As far as its specific location, I believe it was at some point after the Part 2 rebuttal process. I knew that there was a diversion in that channel. I did not know specifically where it was.
And so when these facilities were being designed and the operations being considered, you weren't aware of the specific location of that diversion, CCLP's diversion in the DMC. Is that correct?
No, I was not.
Okay. Have you personally performed any specific studies or investigations other than what you have in the testimony as to the possible operational impacts to CCLP's water rights?
Objection vague and ambiguous. Which water rights is she referring to and where are they located?
Has he done any other analysis?
The question was based on as to CCLP's water rights. We have produced analysis that is in the testimony regarding impacts to that region of the Delta. So without more specificity, it would be very difficult for Mr. Bendarski to know if those water rights fall within the range of impacts discussed in the testimony provided or not.
We can make that inside the water at the diversion.
I'm sorry, that does not
We could,
help.
the impacts to CCLP is a water diversion in the DMC.
And this would be the one located on Mr. Bednarski's figure.
Ms. Womack, if there are other points of diversion that you wish to ask Mr. Bednarski about, it would be helpful if you can show where that is on a map.
You know,
You don't have a map or anything we can show?
where's the map? I wasn't, you know what, DWR, it will give me a minute with that. We'll find a map that would show them. It's very simple. Let's see. Currently, the Jones Channel, you say currently the Jones Channel is subject to existing water level variation and existing southern delta water quality. When the control structure gates are open, the control structure will not be an impediment to the CCLP diversion or inhibit its access, is what you're saying. So you're saying when the control structure is open, it will not be an impediment to our diversion.
That's our understanding at this point, based on our conceptual engineering completed to date.
And are there impact studies to that?
There is my understanding that under our current concept, those gates, which we're believing at this point will be radial gates, will be fully opened when we are diverting water from the South Delta, or when we are doing the combined North or South Delta, and that our goal is to minimize head loss across that structure such that we do not change the water surface elevations for the Jones pumping plant. So we will be configuring that structure to minimize losses across that structure when we're flowing water. Thereby, we anticipate that the water levels at your diversion will remain as they presently are.
But I've asked, do you have impact report, any sort of, you don't?
Go ahead.
Studies.
Ms. Womack, in my testimony, I presented the water level analysis for the what I expect your intake.
You also told me in your on the 10th that you don't have that information to that specificity.
Let's not argue back and forth. If there is a specific question, Ms. Womack, ask it, please.
Do you commit to there no impact on water levels at CCLP?
Objection. Mr. Bednarski has put forward his testimony. He has laid out exactly the basis for his conclusions, and his conclusions are in this testimony. That is a blanket statement. I believe that she should point specifically to the, he has this caveated with sentences. So I would prefer she points to a conclusion he raises here that is supported by the evidence in his testimony and asks him, I guess she could ask him to confirm what is written here, that based on these parameters and the structure that he made this conclusion, for example. I don't want to put words in his mouth, but I don't want him answering a blanket statement apropos of nothing.
I'm just trying to get something that says I've got opinions so far. So,
Ms. Womack, these witnesses have provided testimony. In your closing briefs, you may make arguments as to how you believe their statements might translate into a condition that you might propose. I don't think you'll get much from them if you were to continue to ask whether or not they would agree to various conditions. They have not. Any of petitioner's witnesses have, I think, been careful to avoid making any statements of proposed conditions. So I would suggest that you narrow your focus on specific questions to them that would help you formulate your closing briefs in terms of conditions that you might propose, rather than asking them whether they would commit to something.
Okay, that's fine.
Maybe I can ask
yes.
a clarifying question then, based on Dr. Chilmacurry's response. Just to narrow it down, so Mr. Bednarski, in looking at operational project-based potential impacts, page 3, you did not look at water level impacts of operations. Is that correct?
I don't believe that's correct. Can we go to DWR 1304, the CER? We have information in there that I believe we've presented that shows our expectation as far as water level at the Jones plant, and I guess I'd just like to point that out. Maybe that would answer some questions. So DWR 1304, page 5-7.
Mm-hmm.
Yeah, keep going back up. It's in section 5.1.6.3.
Here we are. Yeah.
There we go. Okay, stop. Whoops, went too far. Okay, stop right there. So for the CVP under isolated South Delta operations, so this would be basically similar to what the current operation is now. For the CVP, we've identified the design minimum operating elevation at minus 1.43 feet with a maximum operating elevation of 9.57. Again, this is to operate the Jones pumping plant within this range, which is their current range of operation from what I understand. Now, if we scroll down just a little bit further, keep going a little bit more, okay, stop there. This bottom grouping of information provides under the dual operation, and you will see that the design operating elevations for the CVP are the same under the dual operation mode as they are under the South Delta diversion only mode. So
yes,
this was our way of characterizing that we do not plan to modify or adjust or change the water surface elevations in that channel.
Yes, I appreciate that so much. However, the elevations now are tidal-based. This is based on operations. This is why operations is huge to me. The dual operation, the isolated North Delta operation, I have a huge range that my farmer doesn't know. We go by suns and moons and high tides, low tides. There's no high tide, low tide with a closed control structure.
And the question is?
Yeah.
Is there any tidal information here with the isolated North Delta operation or the dual operation?
Objection. Vague and ambiguous. Is there any tidal information there? Is she asking whether there will continue to be tides or if these numbers take into account tides? But I think I'd like the question to be more specific.
Agreed.
I would like to know. My water levels right now, I can depend on a farmer's almanac. I can open it up. I know when the high tides, the low tides. Here, I have a huge range, just like I have now, but I have no guarantee. I have no one I can talk to. DFD won't respond.
And I still don't know what the question is.
So maybe I can ask a clarifying question. Through these operations and trying to maintain water levels, is there going to be some mechanism in which CCLP will be able to communicate with DWR, CVP, to know when it will be able to divert?
I would expect there would be some sort of a communication mechanism between the two parties.
But nothing developed right now?
Nothing at this point. I believe we would do that during our preliminary and final design as we get a better handle on any impacts to CCLP's operations, if there are any.
I'm very concerned about communications, given what we have going. Right now, let's see. What I want to know is the water that comes from the North Delta diversion, is that reclamation's water?
Objection.
Right now, I'm
relevance.
getting water from the Old River.
Objection, relevance.
Well, I think I can clarify and
Please do, Mr.
yes.
Emmerich.
And Dr. Tilmacurry, you can certainly join in here. I think one of the issues, and I think Mr. Mizell actually brought it up this morning, is at some point in time, the control structure is going to cut off water from Old River to this diversion point. Water is going to come from the other facility, that North Delta facility. And that water is going to be either, I guess, SWP water, CVP water, origin in Sacramento River. What is going to be CCLP's entitlement to that water? Is it going to be with a contract with CVP? Is it going to be a contract with State Water Project? Right now, they're taking Old River water. That water will not be Old River water. So I think there's a concern is what's going to be CCLP's guarantee entitlement right to that water?
And I'd object is needing a legal analysis and conclusion.
Mr. Mizell, your witness may answer that they don't know, but that is a valid question that goes to potential injury to CCLP's water rights. Your objection is overruled.
I don't have I'm not qualified to be a water rights analysis person, and all I can tell you is that there will be water present at their intake.
By what mean?
Either through opening. If the control structure is open, they will continue to get the water from Old River. If the control structure is closed, the water will come from Tract 4-Bay.
And by what mechanism will it be provided to CCLP?
If you recall that figure I was describing, the channels are, so the South Canal.
You're answering that from a technical, physical perspective, and I guess you cannot answer it from a legal perspective.
Correct. That's the only way I can answer it.
Go ahead.
Oh, no, so the question is, you don't know what the legal entitlement or facilitation for CCLP to use that North Delta water will be. Only that it'll be present.
Well, maybe I could.
Correct. It will be present. I just don't know what. Yeah.
So does your analysis assume CCLP will be able to divert North Delta diversion water at will, is basically what you're saying?
Objection, vague and ambiguous as to at will, but if she truncates that off, I think that question is there.
We will ignore the at will part.
I have
pursuant to your water rights.
I have year-round water rights.
Let's frame it as pursuant to your water rights.
Okay.
Yes, that's my opinion.
And you have the ability to make that commitment.
He is answering that from his technical, physical perspective.
All right, let's move on. And so the control structure, is there a question?
Yeah, I'd like to, at this point, maybe lodge an objection to the continued use of the word commitment, which I think can get a little confusing, whether you're asking someone to commit to what they state in their analysis or based on what they have written here, and whether you're asking them for a commitment that later you're going to come back and is beyond their personal knowledge and is some way a commitment. And I understand earlier we had a little bit of a distinction going, but I think that it's getting a little dangerous to do a continued use of that word. And I think it's now being meant more colloquially, so I do have a problem with that word in the questions. So vague and ambiguous when that word is used.
All right.
I'm very concerned about our water rights.
Yes,
and so I am looking for commitments that are real, that mean something.
And I have already mentioned several times, as has counsel for DWR, that you are highly unlikely to get that level of commitment from these witnesses. But what you may do, and you have done very successfully with Mr. Emmerich's help, is lay the foundation for arguments in your closing briefs with respect to the commitments you would request be placed on any approval issued to petitioners. So, Ms. Womack, you're ahead. Let's keep going.
Okay. as long as you say so. Let's see. Did you want to go into that, maybe? And then I'll do this.
I can ask him about this.
Yeah, that would be great.
Mr. Bednarski, on your testimony, on page 4, lines 2 through 5, you talk about next phases of California WaterFix design process, detailed and extensive hydraulic modeling and assessments of the entire California WaterFix, including the Jones pumping plant intake channel, will be conducted. Can you describe for me in more detail what these next phases of design is going to be and the detailed and extensive hydrologic modeling that's proposed?
And I would object that that is well broad beyond the scope and has been the subject of a lot of testimony in this proceeding. Maybe if the question could be narrowed down in some way, but
sure,
we spent many days going over the level of the conceptual engineering reports and then the next phases that would occur.
Let's try to narrow it, Mr. Emmerich.
Yeah, we can narrow it as to potential impacts to CCLP's diversion.
I guess at a summary level, we'll be completing a hydraulic model or profile of the entire WaterFix system, starting at both the Jones and the Banks pumping plant and looking at a variety of different potential operating scenarios, and then determining, the impact of those operating scenarios on water levels in the Jones intake channel, and then using that information to further develop the configuration and the operational modes for the control structure that's located in that channel, as well as the ones that are located in the interconnection channels. And then, developing, designs and operating scenarios, around those hydraulic models that have been developed. I'm not sure how to be more detailed than that.
So you have nothing that can help me make a decision about things right now. It's going to happen in the future.
Objection, vague and ambiguous. It's also asked and answered now. He just answered that that was the level of detail that he could provide.
So thank you. Let me try to ask a follow-up question, maybe more clearly. So to date, you haven't looked at any of that with respect to impacts to CCLP, but you plan to in your future analysis. Is that correct?
Again, objection as to you haven't looked into any of that.
Well,
you
have not looked at the impacts to CCLP at this time.
And again,
with respect to this future WaterFix design process, detailed and extensive hydraulic modeling and assessments. You haven't done that yet with respect to CCLP's diversion. Is that correct?
Objection. It was asked and answered. He answered what the next step was, and now the question is specific to CCLP. Although that was included in his answer, the question to him was, what is the next step in reference to CCLP? So that question has been asked and answered, and indeed what they're doing is asking for a different answer now.
Sustain.
All right, let's see. Part of mitigation, I want to look at mitigation in the CER. So basically in the CER, that one of the things is that you will have, if there's any problem, you're going to provide groundwater wells or temporary river diversions and pumping capabilities. Could you kind of could you kind of show me, not evidence, but explain how that would happen? So if I have a problem with my diversion, I can't get water. Because this is going to happen once our diversion is going. Is that correct, Mr. Bernardsky? I'm sorry.
Object is vague and ambiguous. Ms. Womack has selected one bullet point out of a long list of potential mitigations and asked if that's the particular mitigation Mr. Benarski would use based upon an undefined circumstance. I think we need more specificity.
Sustain.
Let me see if I can clarify. First of all, where did these mitigation measures come from? Are they in another document? I think some of them are in the EIR, if I'm not mistaken, but I don't believe all of them are. I think some of them are from Ag 1 mitigation from the EIR.
So I'm sorry, let me interrupt and make sure we are clear on the record. Mr. Emmerich, you are referring to DWR 1417, page 5, I believe it is, starting
Correct.
on line
8.
8, yes, with the bullet starting on line 10.
Correct.
All right.
So I'm asking is these mitigation measures something that you personally developed? Did somebody else at DWR develop them? Are they in another document and you're using them here?
I previously presented these mitigation measures. If we go to the top of page 5 here, in DWR, stop right there, line 2, DWR 57. I believe in my part 1 testimony, these mitigation measures were presented because we were specifically talking about diversions along the Sacramento River that would be either temporarily or permanently obstructed by the construction of the intakes. So these have been talked about, discussed in detail before in these hearings.
For the Sacramento diversions.
Yes.
Thank you.
And so we've used those same mitigation measures here now down at Clifton Court LP.
Okay, so looking at the 3 of them, I don't care, all 3, you're going to do ground wells, you're going to provide alternative water supply from a permitted source. Where would that be from?
And just to make clear, we were talking about the 3 bullet points under temporarily affected, so lines 8 through
Yes,
14.
so you're going to drill groundwater, you're going to have from alternative supply from a permitted source, or I don't know how this, once construction is completed, reactivate original diversion and discontinue. So that's not, so there's really 2 ways you're going to temporarily affected what you're going to do during construction.
I'm unclear on the question.
Well, I guess I'd like to know how, if I'm how it takes weeks, if not months, to drill wells. If I'm temporarily affected, drilling a well is not very, I don't know how that will, I don't want my farmer without water. Providing an alternative water supply from a permitted source, where would that be from at Clifton Court, from the DMC intake?
Objection compound. I think she just needs to ask each of those individually so the record is clear. But I heard two distinct questions there about the timing of groundwater wells and then where would the alternative water supply potentially be from, if he knows.
All right, let's break it up. Mr. Bernardsky, answer the first bullet first.
Yeah, I think what we were trying to do was provide several options here that could be evaluated, just like they would be evaluated up along the Sacramento River at the river intakes, and select one of these that is most appropriate for the specific application at that location. In some locations, a new groundwater well may be appropriate. In some locations, a temporary river diversion and pumping capabilities with that diversion may be most appropriate. And then there may be some other alternate water supply. We wanted to have a menu of options to select from so that the most appropriate one could be selected for the specific application. And then finally, the last bullet was to address if there was a temporary impact due to construction, we would reestablish the original diversion point once construction was completed if we were able to do that.
So in other words, you are not able at this time to provide any additional specifics with respect to source of alternative supply or timing for well construction or any additional details?
Or temporary?
No, not at this time, not with the limited amount of information that we have available to us through the conceptual engineering effort.
So then, thank you for clarifying. So then if our diversion is permanently affected, you will provide the measures listed above, until the mitigation measures are complete. So you'll do what's above, or you'll relocate the existing diversion outside of the control structure footprint to a location that ensures the relocated diversion would function in a manner that is equivalent to its current operations.
So let's be clear, you're now talking about if there are permanent effects. You are now focusing on line 16 through 23 of page 5.
Yeah, basically the other bullet points.
Yes.
Yeah.
Is there a question?
The question is, how do you marry that with my right to, my contract to divert water at my diversion point?
I would say vague and ambiguous. I have no idea what she means by marry to her contract.
I'm not sure I understand either.
Well, I have a diversion point in the CVP, in the DMC intake, and this is, now you're going to relocate my diversion. That's changing where I divert water. So changing my water, where I divert my water rights, something that I've had since 1955.
So is your question whether or not Mr. Bernardsky can provide any additional specifics at this time with respect to how DWR would achieve these measures?
Yes.
So I think there were 3 parts to this. As if the diversion point was permanently affected, we would provide temporary mitigation that was described above in the bullets that we just discussed. Then, if the diversion fell within the final footprint, whether it was the construction footprint or the permanent footprint, we would relocate that diversion outside of that footprint to a suitable location that would ensure, water diversions by CCLP as they presently have them. And then finally, we added this 3rd bullet because we recognize the potential, once we start preliminary and final design, that there could be an unanticipated impact to your diversion based on the construction and operation of the gates and the entire WaterFix scheme. So we wanted to leave ourselves the option that even though your diversion was not affected by the footprint of the structure itself, we would still commit to relocating your diversion if, through our hydraulic analysis, we were to determine that there was going to be an impact to that diversion.
So this would be before any construction?
Potentially, if there was not a way to mitigate that hydraulic impact to yours, then we would potentially relocate it prior to construction.
And what if it's discovered after construction?
We've addressed that also. Let's see. Can we go to page 7 of my testimony? Line 1, sentence starting additionally, if unexpected impacts are identified in the design phase or in subsequent operation, they will be mitigated with the measures discussed above. So that loops you back to the mitigation measures that we've already discussed. So DWR is committing that even after operations, if there's something that we missed in our analysis and it affects your diversion, we will take mitigation actions to correct that.
Currently, if there's something wrong, I'm told to sue. What would be the mitigation? This is where I have been told today, or a few days ago, that I have to sue on my water diversion if my farmer's hurt. My farm needs, when it needs water, it needs water. It cannot wait days and weeks while people decide what they're doing. How will this process happen? It's not very clear to me. Can you explain the process?
I'm going to object that that question is vague and ambiguous. I believe that Mr. Bednarski is here to testify as to engineering and as to what is known based on the current level of engineering design on impacts on CCLP. He is not a member of the field division office that Ms. Womack may be dealing with on a daily basis or in some way regarding the operations of the Clifton Court diversion point. So I believe that we are straying outside his knowledge, but that question was so broad and vague and ambiguous that I can't tell what is falling in Mr. Bednarski's purview. So I would ask that the question be reframed.
I guess my question really to overall to anyone that you're my experts here is, what is the process for enforcing your commitments?
Answer?
Well, I believe the answer is generally characterized on page 5 of my testimony. Starts there and continues on to page 6. Can we go to the bottom of page 5?
I'm sorry, could you read it to me? Because I'm not seeing it.
Starting
please
on
give the line numbers.
line 25, DWR will implement this mitigation through the following steps. And there's 1, 2, 3, 4, 5 steps, which to me are characterized by an engagement process between DWR and the owner of the diversion that will take place during this mitigation effort. And it would be my expectation that there would be continuous dialogue during the preliminary and final design as to the findings from the modeling and potential impacts, and that there would be this engagement that's outlined here that would lead to a resolution of the issue.
But there is no, this is your opinion.
This is my testimony, and in the past, my testimony has committed DWR to doing certain things. I would expect that this testimony would be treated the same way.
Let me ask a follow-up question. So this mitigation measure, all these mitigation measures would become part of any change petition order that would be issued by the board? Is that your understanding?
Objection calls for the witness to put himself in the place of the decision makers.
Sustain.
So you don't know. So you don't know what then an enforcement measure might be for these mitigation measures.
Objection also calls for a legal conclusion, so the same
And outside the scope, yes. Sustain.
Objection was sustained, Mr. Emmerich.
We're waiting for OSHA.
I was waiting to be recognized.
Ms. Meserve.
Oh, I just had an objection as well because I believe the question misstates the testimony. I don't believe that the things listed in Mr. Bednarski's testimony are in fact mitigation measures, so I believe it's causing confusion in the record to refer to them as mitigation.
I'm sorry, I did not understand that.
Well, if you, working with affected right holders, they're not very specific, these things that she's very right.
My point is that they're not listed in the MMRP or anywhere else in mitigation measures. Incomplete, parts of them may be. So for us in this hearing to refer to them in questions or otherwise as mitigation, I do not believe is correct and is confusing. They've apparently are commitments being made on behalf of certain witnesses.
We will refer to them as steps.
If there were in your mind, or if you know, or if you've thought about it, if there is some disagreement between a particular landowner and DWR over which mitigation measure to take, would there be a process to resolve that outside of suing DWR or coming back before this board somehow? What would you expect if you said, DWR says, hypothetically, we think you need a well, and the landowner says, well, I think you need to move my diversion?
I think objection that calls for a legal conclusion, legal advice about how a landowner would enforce what Mr. Bednarski is testifying are the steps that DWR has committed to. And so I think this is beyond his purview and beyond the scope.
Well, my question has to do, if I can explain, is you're making commitments that you'll, I guess you, on behalf of DWR, or will take certain measures here, provide a new groundwater well, temporary river diversion, move with Ms. Womack's diversion if permanent. My question is, have you given any consideration, or are you aware of any consideration on DWR's part for any sort of dispute resolution if there's disagreement over which of these measures, steps the landowner wants to take, and maybe DWR disagrees with that?
To your knowledge, Mr. Bednarski, has there been discussion of any such dispute resolution process?
I'm not aware of that.
What if it comes to be that a particular step that DWR wants to take, or that the landowner wants to take, is proven to be infeasible, and there's no feasible alternative? What then? Does the landowner have to sue? Is there a process that DWR will have for dispute resolution within the CWF?
I would say the objection that question became very compound. The beginning part called for a legal conclusion about whether the landowner would have to sue the DWR on any particular grounds. And I believe the end of the question was then back to whether the DWR will have a dispute resolution mechanism. And Mr. Bednarski, of course, may answer to the best of his knowledge based on his personal experience here. That's how Mr. Emmerich would like to rephrase the question based on my objections.
Yes. Answer that question, Mr. Bednarski. Good luck.
All I'm
Could
trying
somebody
to, all I'm
summarize
trying
that
to,
again?
It's a complex question. I'm for just looking for an easy answer, which is, if there's a dispute over these steps between DWR and the landowner, is there, or has DWR given any consideration to how that dispute would be resolved? Litigation, come before the board, come up with a dispute resolution
And
procedure?
Mr. Emmerich, how is that question different from the last question you asked, to which Mr. Bednarski has answered to his knowledge there is no dispute resolution process?
Okay.
Okay. So could that be part of a permit process? I mean, I'm just...
That's up to you. I'm not going to suggest any arguments on your behalf.
Yeah, because, I mean, I have...
Womack, let's move on to your next line of questioning.
Okay, yeah. We've got so many questions. Oh, my goodness. So let's see. Should we start with Mr. Chilmacurry? Is that...
If you would like to start with
Or
Mr.
we just
Chilmacurry, I
about-
can.
Okay, that would be good. I'm going to double check through Mr. Bernardsky's that I've done. I have still my questions from that were never answered, and I need to go back and make sure that those questions that are relevant, that I've asked all of those. So
Len, let's do it.
Okay.
I would prefer not to have to call these witnesses back next week, but I also don't want to be here till 8 o'clock at night. So let's get moving, please. Actually, let me check with Debbie. Do you need a break? Are you sure? All right. I don't know that we can stay beyond 5 o'clock anyway. Okay.
I can ask questions of Dr. Chilmacurry while Ms. Womack.
Please do.
Dr. Chilmacurry, hi. Matthew Emmerich, assisting Ms. Womack today. We've talked before. And I appreciated your testimony and frankness previously. What I'd like to do is start you off by going to page 3 of your testimony, DWR 1421. Line 23, you state that the DSM-2 boundary condition time series for Jones Pumping Plant exports from the South Delta channels reflects the operations of the control structure. No, that's wrong, excuse me. DSM-2 model used to analyze the salinity and water levels in the in Delta for CWF included a representation of the control structure operations, even though the control structure itself was not explicitly included in DSM-2. What do you mean by that?
It means that the bathymetric inputs or the control structure inputs that are that we provide in incorporate in DSM-2 did not include that control structure we were discussing.
So in doing the modeling, the control structure wasn't considered, is that correct?
The physical footprint of that control structure, how it would fit within the DMC intake channel was not part of the model.
Okay. When you did the modeling, was inflow to the Jones Pumping Plant intake channel blocked at times to represent the closure of the control structure?
No, that's exactly what I'm stating there. The way we model that is by turning off the diversion from the Jones Pumping Plant at the Jones Pumping Plant to reflect basically the fact that we are not diverting anything from South Delta channels directly, which would be consistent with shutting down the control structure.
If I could go to page 4 of your testimony. Lines 6 through 19, starting with the control structures on line 6 and concluding with analysis of CWFH3 plus on line 19. With respect to this testimony, how does it relate specifically to CCLP and its diversion structure?
I was explaining the reason I provided that information is basically to indicate that DSM-2, what the DSM-2 inputs were specifically and what they were not. I just wanted to make sure that there is enough evidence or testimony in the record that where you can find that information of what's in the model and what's not in the model.
But I guess my question, maybe I misunderstood, is how this relates specifically to CCLP's diversion and impacts from the Cal WaterFix.
And I'm going to object as vague and ambiguous. Is what you're asking is how Dr. Chilmacurry's modeling applies to CCLP?
How his testimony here is here with respect to bathymetric inputs for DSM-2. How does that relate to any analysis of impacts for CCLP?
We use the DSM-2 model to analyze the expected water quality changes and the water level changes in the Old River, which is what I presented in this testimony. And I was providing this information to make any readers clear where they can look at the information to see what was included and what was not included in the model with respect to CCLP diversion or the control structure we are proposing.
But does this not apply to everything and not just CCLP?
Yeah, because that's the same model we use for everything, but it's also applicable for CCLP.
But not specific to CCLP?
It's not specific to, the only part that's specific to CCLP is the fact that I'm saying it's not explicitly represented. And I'm just providing references where you can see that.
Then I would move to limit his testimony to what he just stated and to strike the rest of this.
Oh, and I would like to respond, and though I would hate to quibble with a hearing officer about the use of the word specific to CCLP, it is unclear. Dr. Chilmacurry is providing testimony here that his testimony states that it is his opinion that this modeling at the Jones pumping plant is indicative of conditions in the stretch of the DMC in which the CCLP diversion intake is present. And certainly Dr. Chilmacurry can speak for himself. So to say that this does not specifically take into account the CCLP assumes facts not in evidence and is a misstatement of Dr. Chilmacurry's testimony. And so boxing him in here when he's explained that this page is providing the model assumptions that he used to reach, for accuracy and completeness of the record, that he used to reach his conclusions about conditions in that channel, I think is a misstatement of his testimony. So I think we've gotten a little bit confused, and I think that and that is why I would oppose any motion to strike here, because I think that we are talking at cross purposes, and that is not what Dr. Chilmacurry said.
I would object. I think Ms. Ainsley is actually testifying on behalf of Mr. Chilmacurry. What I'm just asking is, why is this relevant to CCLP? I understand that there's modeling that's been done and background to the modeling. I'm just trying to understand why
And
you
that is a
chose
much
to
more
put
clear
this-
question.
Put this into your testimony with respect to CCLP.
Yeah, and I was trying to explain that. Maybe I was not very clear. So I can walk you through individual pieces of why I included. For example, we can start on line 17. I referenced DWR 1142, Appendix 5B. The reason I included that is it is important to review that appendix, which is where the DSM-2 modeling methodology has been described, what the assumptions were, the inputs were described. That's where you will find the information that the operation of the control structure is reflected through the boundary condition of Jones pumping plant. And you cannot find that anywhere else. So I'm providing references here in the record that would just corroborate what I'm saying in here.
Mr. Emmerich, do you still wish to file an objection?
I do, because I still think that this testimony is in here for potentially other reasons, and I don't know how it relates to CCLP, but I'll leave my objection at that.
We'll take that objection and Ms. Ainsley's response under consideration.
Yes, and just to support Mr. Emmerich's objection, I think those of us who had believed that we would have an opportunity to cross-examine this panel were concerned that this testimony went beyond just the CCLP diversion, and it's for that reason. So that's why we also agree with that objection.
Understood, which is why we will take that under consideration.
Thank you. Also on page 4, last sentence, you state that you've identified and extracted specific data for the location within DSM-2 results near the junction of Old River and Jones Pumping Plant intake channel, which is presented below. My question is, in DSM-2, there's nodes, correct, in which you look at water quality?
Yes.
Yeah. And for this statement, are you using node 181?
I'm using an output location called rold 046.
And how does that relate to node 182 or 179?
I need to look at the DSM-2 grid. If you have that, I can help answer.
So exhibit State Water Resources Control Board 102 Appendix 5A, Section D, Attachment 6. All I'm trying to find is where this information was gathered from, how close to CCLP this was.
As that is being pulled up, Mr. Emmerich or Ms. Womack, could either of you give me a time estimate for the remaining cross that you have?
Without objections, 20 minutes to a half hour.
In that case, then, we will try to accomplish it today.
Appendix 5A, sorry, 5A.
Yeah, and I have
Section D.
about, in these questions, I've identified 5 or 6 that I need to ask.
Attachment 6, thank you.
I'm sorry, that's in addition to the 20 minutes to half an hour Mr. Emmerich proposed?
Well, these are the questions that I submitted that we're going to
Is that
be.
in addition to Mr. Emmerich's
Yes,
response?
because of the water quality, yeah.
Mr. Long, the link was actually, there was a separate link for that attachment, just to speed this up. You can scroll down. Excuse me?
Speed it up.
Oh, my goodness.
You can see there is a additional modeling section D, attachment 6, right there. Scroll, keep going down, keep going. Yep, right there.
And I've been advised that we do have a hard stop at 5 today. So it looks like we will ask you to return on Monday.
Zoom in towards the south. Yeah. Keep going down. Oh, sorry. Wrong page. Yeah, you see that circle with 1? Can you please zoom into that area, please? At the bottom left. So the outputs that I'm presenting in my testimony, what I'm calling as near the junction of Old River and Jones Pumping Plant intake channel was on channel 80. ROL 46, you see that?
Oh, I see 80.
And ROL 46 is designated on the Old River channel at the junction of Old River and Jones Pumping Plant intake channel. You can see that on the map as well.
The 80, is that within the Tracy Fish Facility?
It's an Old River channel.
Oh, is 181 the Tracy Pumping Plant?
Yes, that's where the boundary condition for Jones Pumping Plant export is applied in DSM-2.
And what is 179? Is that 179 right up at the next link up?
It's within the Jones intake channel, Jones Pumping Plant intake channel.
Okay, and then 70 is, I'm just trying to.
70 is the junction between Old River and intake channel.
So it's at the Tracy Fish Facility?
Yeah, it's as far as I know, the Tracy Fish Facility is within the intake channel itself. It's not, it's a little bit,
the boundary, Old River goes directly by, and that's where they pick up all the.
So that that's approximately where then the node 70 would be.
Okay, and then 80 is on Old River, so it's kind of not quite there.
is 80 on Old River?
Yes.
Okay, but why isn't it in front of the Tracy Fish Facility, I guess? Because that would be closer to Jones.
Are you asking why the location of 80 was placed where it is when it was done?
I think what they're trying to determine is, and you can correct me if I'm wrong, Suzanne, is how these nodes, these numbers, relate in proximity to Ms. Womack's CCLP's diversion.
Right, and I'm trying to explain that that is the, in fact, going back to the previous issue that you raised, Mr. Emmerich, that's exactly why I was including that information in my testimony, so it's easier for anyone to go back and reference and find out what those nodes mean and what the inputs were. But coming back to your question, our old 46, that station, as noted on the grid, is at the junction of the, or near the junction of the Old River and Tracy intake channel. And that's the output location I'm using to prepare the results that I presented in my testimony today.
That looks to be further in. Is the blue the Old River and the channel?
Correct.
Because yeah, where that is located is around the bend from Tracy Fish Facility.
Ms. Womack, what I can tell you is just based on the level of precision we have in DSM2 model, the water quality results in channel 80 would be reflective of or very similar to what you would see in channel 214.
But is my diversion in 214?
Again, this is the point I made in my previous testimony. We don't have that level of specificity in DSM2 model, meaning that your diversion is not explicitly modeled in there. And the control structure is not modeled in there. It's a representation of the Jones pumping plant intake channel. And the best information we can get out of it is what we can, what the water, we are trying to simulate what the water levels may be with and without project. And that's the results I'm showing you right there. I cannot tell you exactly what the water level will be at your intake. That's not the purpose of this model. This is what I'm trying to...
farmer, so I cannot tell my farmer the impact of this WaterFix on his pumping.
That's vague and ambiguous. We've testified to the extent of Dr. Chilmacurry's knowledge. He's made clear the bounds of what he is testifying to and what he is not testifying to. So that is, in a sense, asked and answered. He has explained the level of specificity in his analysis.
But I do want to add one point that I'm showing you there is expected changes because of the WaterFix operations at your intake. And that's in the figure 4 with respect to when the control structure gate is open. Now, when the control structure gate is closed, we would need the hydraulic modeling that Mr. Bernardsky referenced.
Could we put up the control structure, the DWR 1305, I think it's page 87, PDF 87, looking at the control structure? Because oh gosh, it must be 87, 88, 89, control structure. Is that 89? Did we start at 87? There's like 3. I'm looking for the picture. 87, 88, 89 are my, oh, you went by it. That's the control structure. So the no action alternative, is that your, Mr. Chilmacurry or Mr. Bernardsky, that says that the no action alternative and having the gates open are the same for the water levels?
We've provided at least 2 different alternatives for the control structure. This is one of them. We do not have a final configuration for that. We will be developing that as we get into preliminary and final design and do our hydraulic modeling. But if our goal is to keep the water levels in the channel basically the same as they are now, I don't expect that we would use something like this, because the way the structure obstructs the channel, we're going to get a lot of hydraulic losses across that structure, and so you would see a much lower elevation on the downstream side. I would expect we're going to use some type of a radial gate structure that can be lifted entirely out of the water in order to preserve the current tidal influence in that channel and keep us within the water surface elevations that we presently have at the Jones pumping plant, which would translate to basically attempting to keep your water level at your diversion point where it is now, riding on the tidal influence.
But you don't have any, and the radial gates, these are the radial gates like the radial gates at the Clifton Court forebay that are stuck, one's been stuck open for 2 years. I'm just trying to figure what it would look like, because this to me impedes the control, this impedes the waterway.
A question rather than argument, please.
The question, so your answer, let me just to clarify, your answer is you're not using this, but you don't have anything that shows what you are using.
No, I think as I've tried to explain several times, we have several concepts for this location. And once we do our hydraulic modeling and understand what restrictions we have, we would then narrow the choices to a preferred alternative. And one of the criteria for that alternative would be to have minimum or no disruption to the current water surface elevation fluctuations that occur during the kind of the tidal sequence. And that will take place in the next stages of design.
Where are those documents that show the different control structure? Because I'm very interested in what this is going to look like.
Well, if Mr. Long can go up one page, we have another alternative that we listed. It's a radial gate option. And then if you go to the next one, we have another.
I can't.
The next page up, we could have another option that we've listed. So we've shown several different options that could conceivably be used at the different locations. And that's what we've attempted to do here, is have, again, a menu that we can further develop in preliminary and final design to meet this hydraulic criteria that we know we have to meet.
Is there a reason you don't have pictures? You have a picture of one, I thought these were all the same radial gate because, well, because I don't know which, it says it's a control structure. I don't know, there was nothing to tell me there are 3 different. Well, do you have pictures of them? What they look like? You have the one picture that you say you're not going to use, this 1305. Where are the other pictures?
And I'm going to lodge an objection that this is argumentative. These are the schematics. He's showing where the options are laid out. It lacks foundation that there should be pictures necessarily in the CER map book or drawings. And so I think that the question is frankly just argumentative. If she wants to ask if there are other representations like that one in this document or any other document, that's a little differently framed than how this is now being framed.
Sustain.
I could ask it that way. Are there other documents that look like this anywhere in the CER I want information.
We'll be preparing that information in preliminary design. We'd be happy to share that with you at that time.
All right. Thank you. On that note, we're going to adjourn for the week. Mr. Mizell.
Yes, I have a quick question that maybe Mr. Emmer can ask or answer. Sorry. In the question that followed the motion to strike, it became quite clear why Dr. Chimokuri has the technical data contained in page 4, lines 6 through 19. When he was questioned about the accuracy of DSM-2, we went into the node charts and into the cross sections and actually spent some time discussing which are closest to CCLP's diversion point and which would be most accurate. At this time, does Mr. Emmerich wish to withdraw his motion to strike?
No, thank you.
Thank you. On that note, we will adjourn until 9:30 on Monday. We will see you then.
Thank you.